ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಮುಗಿದ್ಮೇಲೆ ತಗೋತಾರಾ? ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
Any memos?
Lordship, matter for
Lordships,
tomorrow,
kindly-
Lordship. The parties have settled the dispute, my Lordship. They want to report the settlement for tomorrow, my Lordship.
File it, file.
Yeah, 2:30.
Blood one matter for withdrawal, my lord. List number 2, serial number 11. Matter may be dismissed as withdrawn, my lord. 11, list number 2.
Serial number 11. List.
L. Sudarshan. Sudarshan L.
Sudarshan, counsel for the petition. Filed a memo. Really need a note for it. Memo is placed on record. Question is appeal is dismissed. Pending IA also.
My lords, this matter is of the year 2021, my lords. It is still not admitted. It may be disposed of during admission only, my lords. Hence, I pray for tomorrow's date.
File it.
Any adjournment? List 2, page 4, serial number 33,
My lord.
page 5,
List one,
36,
serial
my
number 31, my.
Serial
page 5, serial number 34 to 37.
36, my lords. Senior
36.
elder brother has passed away, my lords, so he is not here. My lords. List number 2,
Represent-
serial number 36.
You are representing whom?
Respondent, my lords.
Who is for the appellant? Counsel for respondent, praise for time. This time.
Please.
Yes.
List 1, page 1, non-compliance of office objection for first time, serial number N1, Sushant Venkatesh Pai.
My lord, I appear for the appellant, my lord.
Yes.
Pray for
Praise for time.
3 weeks.
Counsel for the appellant, praise for time. List on.
Serial number 2, Sushant Venkatesh.
My lord, same.
Yes.
3, Suyog Irale.
For the petitioner, my Lords, complied during the course of the day, 2 minor objections.
For time.
Serial number 4 to 7, Sushant Venkatesh.
My lord, same submission is serial number 1 and 2.
Yes.
3 weeks time. In
Same. Yes.
Wait.
Serial number 8, Keshav Murthy.
Pass over.
Serial number 9, Suprita KH.
Observe no representation. Next.
10, Hemant Kumar K.
IA number 2 not valid. Condonation of delay in time ಇದೆ ಮೇಲೆ
ಮತ್ತೆ ಬೇರೆ ಇನ್ನೂ ಇದೆ. There are other office objections as well.
ಇಲ್ಲ ಮೇಲೆ
That is the only objection.
only office object.
Counsel
It
for
may
the
be
appellant filed a memo
one third.
seeking permission to withdraw the application. IA is to 2024. Memo is placed on record. IA is dismissed as authorized. When counsel for the appellant submits that, thus say has complied with all the office objections, office to verify. If office objections are complied with, list for orders. Next.
Non-compliance for second time, serial number 11, Manjula D. Vijay Kumar.
Since Manjula D is not a panel right now, my lord, kindly change the name from Manjula D to K. Prasanna Shetty, my lords.
Prasanna Shetty is submitted.
Vijay.
Manjula is not in the panel of the appellant anymore. And he undertakes to appear for the appellant. Submission is placed on record. Office is directed to delete the name of so-and-so and show the name of so-and-so. Counsel for the appellant prays for time to comply with the office objections. Next.
Serial number 12, Manjula D.
Lords,
Same.
my lord.
Same. Next.
Serial number 13 and 14, Sujaya KL.
Counsel for the appellant is absent, no representation. This time.
15, Kiran Kumar DK.
Absent, no representation. ಎಲ್ಲ ಹಾಕಿದ್ರು Leonard counsel ಅದೆಲ್ಲ ಹಾಕಿ. Yes.
16, BS Prasad.
Here for the applicant, your honor. 1 week time may be given for
Yes,
the
for time.
compliance of objection.
17, Sharana Basappa.
Absent, no representation.
18, Ajit A. Shetty.
Absent, no representation.
19, Ravi Chandan.
Absent, no representation.
20, Aditya Narayan.
Appearing for the appellant, my lords, kindly grant 2 weeks to comply with office objections.
Yes.
21, Manjunath H.
Absent, no representation.
22, Nagesh S.
Absent, no representation.
1 week time, your lordship.
Prays for time.
23, Lakshmipati VM.
Absent, no representation.
24, P. Prasanna Kumar. P.
Absent,
Prasanna Kumar.
absent, no representation.
I appear for the petition.
Your Lordship, the office objection is with respect to the counsel who will be representing the appellants. It is the special public prosecutor, my lord.
ಯಾರಿದು DOSP ನೇಮ್ ಏನು ಬೇಡವಾ?
Your Lordship, the CBI will be represented by special public prosecutor.
You have not stated so in the cause title.
It is mentioned as DYSP, who is the investigating officer in the case, my lord. We do not represent by the name.
Mention it.
Please, I'll make the correction.
Pass over. Pass over.
Serial number 25, Manjula D.
Lordship, since Manjula D and Vijay AD,
Same. ಹಾಕಿ ಅದಾದ್ಮೇಲೆ raise for time. Appeal is of the year 2020. It is listed for the third time for compliance of office objections. List finally as the last chance.
Yes.
Next.
Serial number 26, Hemant Kumar S. Sir.
Pay for appellant, madam. Needfully as.
The appellant submits that needful is done. Office is directed to verify. If office objections are complied with, list for orders.
Much.
Serial number 27, Ashok Kumar Shetty.
Applicant, kindly grant a 1 week time, madam.
Sir, it is posted finally, sir. Do the needful. Pass over.
Serial number 28 and 29, Murali N.
For the appellant,
Hmm.
pray for a week time.
ಏನೇನಿದೆ? Counsel for the appellant prays for time. The
Third-
appeal is of the year 2022. It is listed for the third time. I do not find any reason to third time for complaints of office objection. I do not find any reason to adjourn the matter. However, to afford final opportunity. 28, 29 ಎರಡು ಕೂಡ. Finally, next.
30, Krishna S. Vyasa.
For appellant, praise time, 1 week time. will be used.
ತಗೊಳ್ಳಿ. Finally, as the last chance. Next,
31, Jagdish J.R.
Appeal, sir, petitioner, kindly grant 1 week time, my lord.
same. Finally, as the
32,
last.
Fayaz Saab. Finally.
Absent, no. Finally. Pass over. Pass over. 32 pass over.
33, Manjula D. Finally.
Lordship.
Huh.
Since Manjula D,
It is posted finally, sir. Pass over.
please, my lord.
For order, serial number 34, PB Umesh.
For the appellants, my lord, kindly 1 month time may be granted, my lord, because officers are changed, my lord.
Hmm?
That is, the officers are changed, my lord, to execute the warrant, my lord, so far as accused number 3 is concerned.
Hmm.
Respondent number 3 is concerned, my lord, so far as other respondent is concerned, my lord, they are served. So far as the
Representing whom?
NCP, my lord, appellant, my lord.
Learned counsel for the appellant prays for time. To execute the NBW issued against respondent number 3. This time.
And if reissue NPW, my lord.
ಯಾವಾಗ? Reissue NBW. Reissue NBW against respondent number 3 with a direction to the appellant to execute the same. If in case of execution of the NBW, respondent number 3 is directed to produce before the jurisdictional magistrate for the purpose of to enable him to pass necessary orders for remanding respondent number 3 to custody. Yes.
Serial number 35, Government Advocate.
Kindly pass over, my lord.
Pass over.
36, MR Method.
For appellant, Rashid.
36, my lord. Respondent counsel is a government advocate, my lord. She is disabled. She has to give NOC wakalat, my lord.
Who will file?
My lord, we have to give NOC.
Huh?
Advocate on record is to give NOC wakalat, my
He has to give,
lord. My lord. That time will be granted.
he has to inform the party.
Please.
Then non-compliance of office objections on IA. IA filed by
Appellant, Rashid. Permission to-
non-compliance of office
Please,
objections.
sir. 1 week time.
Counsel for the appellant prays for time.
Serial number 37, Naveen CP.
At the end, 2019 application. How long it will take? I'll dismiss this. ಏನಿದೆ ನೋಡಿ pass over.
Rashid, 2 days, 2 days.
No, pass over. 2019 application, ಇನ್ನೂ ಕೂಡ. Yes.
Serial number 37, Praveen CP. Waiting notice, ma'am.
ಯಾಕೆ ಇನ್ನೂ ಬಂದಿಲ್ವಾ? ಯಾವಾಗ ಇಶ್ಯೂ? ಫೆಬ್ರವರಿ. ಇನ್ನೂ ಬಂದಿಲ್ವಾ? ವೆರಿಫೈ ಮಾಡ್ಲಿಕ್ಕೆ ಹೇಳಿ.
ಅಲ್ಲಿ ವೆರಿಫೈ ಮಾಡಲ್ಲ.
ಫೆಬ್ರವರಿಗೆ ಹೋಗಿದೆ.
ಅದೇ ನಾನು ಹೇಳಿದೀನಿ.
ಪಾಸ್ ಓವರ್.
Serial number 38, Kempraju. Permission of,
Lordship, pertaining to securing of correct address of respondent, my lord. This is the address mentioned in CC and the criminal appeal, my lord. We are not able to secure other address of respondent.
That 5 months have lapsed.
My lord,
Still you are not in a position to give.
no, my lord, we are
correct
trying
address.
our best. We are not able to secure respondents.
Then I will dismiss the appeal.
Lord, this is the address in CC and criminal appeal. She has appeared, my lord, in CC and criminal appeal. But here she has changed the
ಏನಾಗಿದೆ?
address. We are not able to get it.
Return ಏನಾಗಿದೆ? Endorsement. Then counsel for the appellant submits that the respondent is residing in the very same address, but evading the service of summons issued by this court. Submission is placed on record. Issue NBW against the respondent. Police is directed to execute the warrant against the respondent wherever she is with the assistance of the appellant. You have to assist the police.
Please.
NBW is issued. Next.
39, Tepegoda. Notice. Await.
Non-receipt, verify me. Pass over.
40 also.
40, Sushal Tiwari.
No, that is the income tax department
for
is
appellant.
appellant madam.
But I will do the needful.
ಏನ್ needful?
ಇದು ನೋಟಿಸ್ ಸರ್ವ್ ಮಾಡೋದಕ್ಕೆ ಅಡ್ರೆಸ್ ಫರ್ನಿಶ್ ಮಾಡಿದ್ವಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಪ್ರೊಸೆಸ್ ಫೀನು ಪೇ ಮಾಡಿದ್ವಿ.
ರಿಪೋರ್ಟೇ
Report.
ಬಂದಿಲ್ಲ, ಸರ್ವಿಸ್ ಆಗಿದಾ ಇಲ್ವೋ ಅಂತ ವೆರಿಫೈ ಮಾಡಿ ಏನಾಯ್ತು ಅಂತ. Let him pass over. Please verify.
41, Harish Bandari.
2 weeks time is prayed, lords.
Notice sent to respondent is returned unserved as endorsement that is not found in counsel for the appellant pays for time. Yes.
Grateful, lords.
42, B.N. Jagdish.
Appearing for the appellant, my lord, we are trying to get in touch with the respondent in order to get the correct address, therefore seeking a 3 weeks time.
Praise for time to furnish correct address. Next.
43, Mandula D.
Grateful.
Permission of the appeal paper.
Since
So
Manjula is-
submit the Manjula D. ಅವ್ರ ಬದಲಿಗೆ ಮತ್ತೊಂದು ಯಾರು? Counsel for the appellant pays for time. This down. Next.
List 2, serial number 1, 719.
ಅದು ಹೆಸರು delete ಆಗ್ಬೇಕು Manjula D. Next.
Appearing on behalf of the appellant, my lord.
P.S. Sachin.
Third land counsel for the appellant on A2 of 2019.
Lordship, this is an appeal against a order of acquittal.
To prosecute the appeal. For the reason stated in the affidavit application and note code. A2 of 2019 is allowed, leave is granted. This part, next stage is that. Yes, IA is allowed.
Much.
Serial number 2, Venkatesh Sarbati.
For the appellant, my lordship, there is a delay of 256 days in filing the appeal, my lordship.
Then comes appellant filed application IA1 of 2019 seeking condonation of delay of 256 days in preferring the appeal. Since there is inordinate delay in preferring the appeal, IA1 of 2019 is ordered to be heard along with the merits of the case. List for all for trial court records, list for admission along with IA1 of 2019. Admission along with IA. Next.
Serial number 3, M.R. Balakrishna.
ಅದು ಸೇಮ್ ಸ್ಪೆಷಲಿ ಅದು ಫಾರ್ಮೇಟ್ ಇದೆ ಅದೇ ತರ ಮಾಡ್ಬಿಡಿ. IA1 of 19 is allowed.
Yes, LCR may be called for, 2019, madam.
Records list for admission. Yes,
Date may be fixed.
ಕೊಡ್ತಾರೆ. ಒಂದು ನಿಮಿಷ ಇರಿ.
Number
Next.
4,
Much obliged.
Mallikarjuna M.
Counsel for the appellant is absent no representation. IA1 of 2024 is filed, seeking early hearing. The appeal is not yet admitted, hence IA1 of 22. Appeal is already admitted. Hence, and in view of the above, IA1 of 2024 is disposed of. This for final hearing.
Serial number 5, Sanat Kumar Shetty K.
Hearing for the appellant in this case.
Especially IA allowed. IA is allowed. All for trial court record, list for admission.
Much obliged.
Next.
Number 6, Venkatesh Sarbati, 321.
321 days delay is there, my lordship.
Along with, list for admission along with application.
Notice has to go, man.
Notice illa. First you make out a ground.
Yes, ma'am.
Order.
Serial number 7, KV Satish Chandra.
Then counsel for the appellant is absent or representation. IA 1 of 2019 is filed seeking condonation of delay of 55 days in preferring the appeal. IA 2 of 19 is filed seeking grant of leave to prosecute the appeal for the reasons stated in so and so. Both the applications are allowed. Delay of 55 days in preparing the appeal is condoned. Leave is granted to prosecute the appeal. All for trial court records, list for admission. Next.
Serial number 8, Government Advocate.
Not for that. The delay, my lord.
Third, learned counsel for learned HCGP on IA 1 of 2022 filed for seeking condonation of delay of 104 days in preferring the appeal for the reasons stated in so and so. The affidavit application. IA 1 of 2022 is allowed. Delay of 104 days in preferring the appeal is condoned. All for trial court records, list for admission. Yes.
9, Murthy Venkatram Ganapati.
Especially allowed. Observe no representation. List for admission. Next.
10, Radhanandan BS.
Third, learned counsel for the appellant, IA 1 of 2024 is allowed. List for admission, IA is allowed. Next.
Serial number 11, Dispose 12.
And notice be issued, my lord.
No, for admission, sir.
Only-
Make out a ground. Later. it will
Only
be-
ground is, the resolution is not produced.
No, no, let me consider that. Yes, 12.
One on the DS.
Counsel for the appellant is absent, no representation. IA 1 of 2020 is filed seeking condonation of delay of 592 days in preparing the appeal. Since there is not any delay in preparing the appeal, IA 1 of 20 and 1 of 2022 are ordered to be considered along with merits of the case. Hence call for trial court records, list for admission, along with IA 1 of 20, 1 of 2022. Yes.
13, M. Subramani.
That is same, IA 1 no 20, no good. Next.
14, Vasant Kumar N.
Absent no representation, IA 1 of 20 is allowed, special leave granted. Next.
15, M. Subramani.
Absent no representation, IA 1 hour, special leave, condonation delay 19 days, allowed, both allowed. Just for admission. Next.
16, S. B. Lakshmi.
Same, absent no representation.
17, E. Sanmati.
Yes.
There is delay of
139 days.
this is the income tax appeal, my lord. Your lordship, there is delay is due to the communication, my lord. Correspondence between the departmental officers, we could not get the authorization in time, my lord.
Third learned counsel for the appellant on IA 1 of 20 and 2 of 20, which are filed seeking leave of the court to prefer an appeal after condoning the delay of 139 days in preferring the appeal for the reasons stated also. IA 1 is allowed, IA 1 of 20 is allowed, special leave is granted, 2 of 20 is allowed, delay of 139 days in preferring the appeal, condoned. All for trial court list for admission. Both the applications
And notices have to be issued.
notice amen. First make out a ground. Next.
18, Sushil Tiwari.
IA 1 of 2020 is
18,
allowed.
18.
Leave is granted.
In other business.
IA is allowed. Next.
19, Manjula D.
Since Manjula D and Vijay AD are not the panel, my lord.
Huh?
Manjula D and Vijay AD are
ಅದನ್ನೇ
not.
ಹೇಳ್ತಾ ಹೋದ್ರೆ ಹೇಗೆ ಸರ್
My
ನಿಮ್ಮ
lords-
ಹತ್ರ ಲಿಸ್ಟ್ ಇಲ್ವಾ
My lords,
ಯಾವ
list is-
ಕೇಸ್ ಅವರಿಗೆ ಅಲಾಟ್
Please, my
ಆಗಿದೆ
lords.
ಅಂತ then
No, my lords, we have the list, my lords. Kindly change the name, my lord. That's
Why
all
don't
I'm
you-
asking. We have
What's the
filed
argument?
we are filing the memo of appearance, my lord.
in this case whether you have filed it
Today we have filed, my lord.
when today
Today, yes, please. My lords, there is a delay, my lords.
Manjula D ಇದೆ. So and so submits that he has filed memo of appearance. Office is directed to so and so. IA 1 of 20 is filed seeking condonation of delay of 1,155 days in preferring the appeal. Since there is inordinate delay in preferring the appeal, IA 1 of 2020 is ordered to be heard along with along with merits of the case. Hence call for trial court reports. List for admission along with the application. Next.
20 same, Manjula.
20, the same. 206 days.
Please.
Government advocate,
There is a delay of 233. There is a delay of 233 days.
No. Procedural delay, no. Not on a merits, not on, along with merits.
Yes.
Along with merits, sir. Yes. Next.
22 Jairamaya,
Third on counsel for the appellant on so and so.
18 days
Special
delay.
leave granted, delay of 18 days condoned. Alpha trial court records, list for admission. Both the applications allowed, list for admission. Next.
23 Karthik Bhargav,
The appellant in this
Heard.
case, Your Lordship.
IA 1 of 2021 allowed, leave is granted. Alpha trial court records, list for admission. Next.
24 EI Sanmati,
Third so and so, IA 1 of 2022 allowed, leave is granted, list for admission. Next list.
25 Jeevan J. Neralgi,
Your Lordship, Jeevan J. Niragi, he is not there in the department now, my lord. My name may be shown for the appellant, my lord.
You are representing
Yes, my lord. I have
when it comes to EI Sanmati submits that he is representing appellant. Have you filed memo of appearance?
Yes, my lord, I will file, my lord.
Undertakes to file memo. This is directed to delete the name of so and show the name of so and so. Heard and counsel for the appellant on IA 2 of 2021 seeking leave of the court for the reasons stated in so and so. IA 2 allowed, leave is granted, call for trial court records, list for admission.
Please.
26 Government advocate,
Heard on
85 days.
HTTP on IA 1 of 2024 seeking leave, condonation of delay of 85 days in preferring the appeal. Adu allow ಮಾಡಿ admission. Yes. Next.
27 Ananta Padmanabha,
For the appellant, heard so and so, both IA allowed, leave is granted, condoned delay of 88 days. List for admission, both the applications allowed. Next.
28 Abhimanyu Arjun,
Heard and counsel for the appellant on IA 1 of 19 allowed, leave is granted, list for admission. Yes.
29 Pradeep Nayak,
For the appellant, 138 proceedings.
Heard so and so, IA 1 of 2024 is allowed, list for admission. Yes.
30 Manjunath BK,
Counsel for petitioner, my lord. Non-compliance officer objection, my lord. Kindly 2 weeks time granted.
Office objections ಎಲ್ಲಿದೆ?
list 2 serial number 30 BK Manjunath,
Absent no representation. IA 1 of 2024 is filed seeking leave of the court for the reasons stated. IA is allowed. List for admission. Yes, next.
31 Pawan Kumar,
For the appellant. There is a 148 delay, man.
Why?
So senior citizen, my lords.
Senior citizen ಆದ್ರೆ delay ಆಗ್ಬೇಕು ಅಂತ.
ಅವ್ರಿಗೆ ಹುಷಾರಿರ್ಲಿಲ್ಲ ಸ್ವಾಮಿ. She was applied for
ಕೊಡಿ ಅಲ್ಲಿ ಆಗ್ಬೇಕು.
appeal against the 138 petition.
What you have stated in the affidavit?
During the trial, she was suffering from the ill health, my lords. 66-year-old, my lords.
Is it the reason assigned? Is it the reason stated in the affidavit?
Yes, please, my lords. Para number 5, my lords.
Counsel for the appellant on IA 1 of 1 and 2 of 2024. Filed for seeking leave of the court to prosecute the appeal, condoning the delay of 148 days in preferring the appeal. It stated that the appellant was suffering from ill health. The appellant was aged 66 years and was suffering with ill health, and therefore there was delay in preferring the appeal. Yes. The reasons outlined in the affidavit are accepted. IA 1 and 2 of 2024 are allowed, leave is granted. Delay of 148 days in preferring the appeal condoned for trial court records, list for admission. Yes.
Macho.
other hearing serial number 32 Trivikram Siddharth Bhimanchandji,
Not pass over, my lord, for the petitioner. Request for a short pass over, my lord.
I am for the respondent number 2 in this matter, please. Yesterday the matter was heard.
Yes, yesterday it was
Supposed to be
heard.
continued, please.
So
Please.
why it is to be passed over?
My lord, I need to file certain documents, my lord. Your lordships asked me to. I'll be there in 10 minutes, my lord, before your lordships, physically.
Pass over.
Great.
For further submission, serial number 33, Divya Purandar, S. Venkateshwaran.
Kodi, lordship. Further submission.
But in this case, the council is seeking for pass or not.
Pass over.
For final hearing, serial number 34, G. Ravishankar Shastri, P. A. Chandrasekhar.
Madam, 33.
Lordship Kodi. First time. Finally.
Serial number 35, V. B. Shivkumar, H. V. Subramanya.
I appear for appellant, my lords. My lords, on the previous hearing date, the respondent submitted that the accused is passed away, my lords. Hence, the appeal stands abated. We're filing memo with this regard, my lords.
Kodi. Counsel for the appellant filed a memo. Report. ಏನ್ ಬರ್ದಿದೆ ಕೊಡಿ. The memo stating that the respondent accused has died and therefore the appeal stands abated. Memo is placed on record. Appeal is dismissed as abated. Yes.
Serial number 36, P. S. Prasad.
36
For appellant.
36.
Yes.
For appellant.
ಅದೇನು ಅವರು ಅದರ್ ಸೈಡ್
ಸುಂದರ್.
ಕೇಳಿದ್ರ ಅದೇ ಫೈನಲ್ ಏನಾದ್ರು ಗೊತ್ತಾಗಿಲ್ಲ. Other side has taken time.
Please. Date may fix, madam.
Further date. Next.
Serial number 37, Sunita H.
Final ಇಂದ ಹಾಕಿ ಅದು 36 ಅದು ಈಗ ಬರೀ then counsel for the respondent place time.
Serial number 37.
1 minute. The appeal is of the year 2014. Order sheet dated so previous order sheet in spite of that, counsel for the respondent is not ready. Please final, both the learned counsel are directed to address their arguments on the next date of hearing without fail. List finally as the last chance. Yes, 37.
37, Sunita H. Singh, Anumesh.
Await TCR. 37, await TCR. ಯಾವಾಗ issue reminder.
Serial number 38, Government Advocate.
My lord, the offenses are 323, 506 and 3, 1 and 10 of SCST Act, my lord. Now, the reasons for acquittal are that, my lord, there are discrepancies in the evidence of the injured victim and the eyewitness, my lord.
1 minute. How many accused are there?
There is only one accused.
323.
506. And section 3, 1, 10 of the SCST Act.
Who is the complainant?
Complainant is the victim himself, the victim, my lord. PW1.
PW1.
Please, my lord.
Whether supported?
Yes, my lord, he support.
PW2.
PW2 is the eyewitness, my lord, was turned hostile, my lord.
Then
PW3 is also an eyewitness, my lord, supported the case of prosecution.
then
PW4 is the wife of the victim, my lord, who took the victim to the hospital for treatment. And PW5 is the merger witness, my lord, for the exhibit P2 spot merger. Supported, my lord. PW6 is the carrier of FIR, my lord. PW7 is the sub-inspector who registered the crime, my lord.
8.
PW8 is the police superintendent, my lord, who filed the charge sheet after completing the investigation, my lord.
Yes.
And PW9 is the doctor, my lord, who has issued the wound certificate.
Yes. As per the wound certificate, what is there?
There are 3
Wound
injuries.
certificate is the exhibit.
That is at exhibit P11, my lord.
How many injuries?
3 injuries, my lord.
Simple.
Yes, my lord.
All simple. Injuries.
All simple. Only 323 is,
Yes. Why the accused was acquitted?
My lord, the reasons given by the Sessions Court is that, my lord, there are discrepancies in the evidence of PW1, that is the victim, and also the eyewitness, my lord. And there are no clinching material has been produced by the prosecution through material witnesses, my lord. My lord, the reasoning is in para number 24, my lord, in page number 21 of the judgment, my lord.
Para number?
24, my lord. In page 10 of the judgment and
yes,
21 of the petition. May I read that, my lord?
Yes, please read.
In view of the above, a further scrutiny of the materials placed before the court by the prosecution, in the instant case, it could be seen that PW1 and the eyewitnesses have given contrary testimony consisting so many discrepancies, as it is an admitted fact by PW1 that there was enmity between his brother-in-law Ramesh and the accused. So also it is an admitted fact that the brother-in-law Ramesh has written complaint exhibit P1 and he do not know the contents. Further, PW1 has clearly and categorically admitted in his evidence that he has a drinking habit, and apart from the above, his evidence reveals that for the first time he is deposing before the court that the accused abused in filthy language and he has put his several signatures in the police station and he do not know the contents as per exhibit P2 and P3. If we go through the evidence of PW2, who is the eyewitness, as per prosecution, noticing of incident by him leads to doubt. So also his presence, as at one breath he has
According to
deposed.
you, PW2 has turned hostile?
Yes, my lord.
Video.
PW3, my lord, who has supported the case, my lord. Further, my lord, he turned hostile partly. Further, PW2 has admitted in his chief examination itself that he has not seen what hurt caused to PW1. And he too has admitted that PW1 is a drunkard. If we go through the evidence of PW3, who is one more eyewitness to the alleged incident, his presence at the tailoring shop no doubt can be believed. But in view of the clear admission given by him stating that as he is in his tailoring shop, he will not bother what will happen outside the shop. Further, he has clearly admitted that he do not know the incident personally. In view of the admissions given by PW2 and PW3, who are the eyewitnesses, noticing of incident by PW2 and 2 itself leads to doubt. Therefore, here there is no wrong if it can be quoted that the eyewitnesses are eyes and ears of justice. Eyewitness account requires careful independent assessment and evaluation for its credibility, which should not be adversely prejudiced or any other evidence as sole touchstone for test of such credibility. Further, reliability of the evidence of the eyewitnesses depends upon the accuracy of the witness' original observation of the events, which he described, correctness and the extent of what he remembers and his veracity. The court should consider whether in this circumstance of the case it is possible to believe the presence of these witnesses at the scene of the crime and whether there is anything inherent improbable, so on. This is the only reasoning, my lord, given by the trial court.
Adverse inference was drawn against the prosecution.
Yes, my lord.
Court has formed an opinion. It is, there is no believable or trustworthy
Yes, my
evidence.
lord.
Why it is to be interfered with?
My lord, the victim, who is himself an injured person, my lord, he has stated about the incident, my lord. Supreme Court in various judgments, my lord, it has to
Interested
be believed.
testimony. He was having ill will against the brother-in-law of the accused.
The dispute was with the brother-in-law and the accused, my lord, not with him, my lord.
ಅದು ಡಾಕ್ಟರ್ಗೆ ಏನ್ ಹೇಳಿದ್ದಾರೆ ಬಿದ್ರೆ ಆ ರೀತಿ ಆಗತ್ತೆ ಅಂತ. Is it not? PW9.
But PW9 is the doctor.
ಮುಟ್ಟಿದರೆ ನೋವು, ಮುಖದ ಮೇಲೆ ತರಚಿದ ಗಾಯ, ಮುಟ್ಟಿದರೆ ನೋವು ಅಷ್ಟೇ.
Yes, ma'am. Lord, he says, my lord, ಒಬ್ಬ ವ್ಯಕ್ತಿಗೆ ಕೈಗಳಿಂದ ಹೊಡೆದು ಕಾಲಿನಿಂದ ತುಳಿದರೆ ಆಗುವ ಸಾಧ್ಯತೆ ಇದೆ ಅಂತ ಹೇಳಿದ್ರು.
ಒಬ್ಬ ವ್ಯಕ್ತಿ ನೆಲಕ್ಕೆ ಬಿದ್ದರೆ ಒರಟಾದ
ಸಾಧ್ಯತೆ ಇದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ, my lord. But the injured, my lord, he says, my lord, the accused
ಅಂಡ್ ಮೊರೋವರ್
assaulted
ಗಾಯವನ್ನು
him, my lord.
ಪರೀಕ್ಷಿಸುವ ವೇಳೆ ಗಾಯಗಳು ತಾಜಾ ಆಗಿದ್ದರೆ ಅದನ್ನು ಗಾಯದ ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ನಮೂದಿಸುತ್ತೇನೆ.
Yes, ma'am.
ಫ್ರೆಶ್ ಅಂತ ಇದೆಯಾ? ಇಲ್ಲ. ಬಿದ್ರೆ ಆಗ್ಬೋದು ಅಂತ ಹೇಳ್ತಾರೆ, ಫ್ರೆಶ್ ಅಂತ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ. ಅಂಡ್ ಯುವರ್ ಓನ್ ಎವಿಡೆನ್ಸ್ ದಟ್ ಈಸ್ ಎ ಡ್ರಂಕರ್ಡ್. ಯಾವ್ದದು? ನಂಬರ್ 2, ಇಂಜುರಿ ನಂಬರ್ 2 ಅಷ್ಟೇ ಇರೋದು, ಅದು ತರಚಿದ ಗಾಯ, ಮೇಲ್ತುಟಿಯಲ್ಲಿ ತರಚಿದೆ. ಎಸ್, ಐ ವಿಲ್ ಡಿಸ್ಪೋಸ್. ತಗೊಳ್ಳಿ. The state represented by so and so. Referred this appeal. Impugn the judgment dated 5th July 2018, passed in special case number 5 of 2015, the file of the learned second additional district and sessions, bracket null, special judge D.K. Mangaluru, acquitting the accused for the offense punishable under section 323 by 06 of IPC and under section 3(1)(10) of SC/ST Prevention of Atrocities Act, hereinafter referred to as such. The facts of the case are that PW1 has logged the first information with the which police station? With the Bantwal Rural Police Station against the accused, alleging commission of the offense, punishable under section stated above. It is his contention that on 5/11/2014, at about 7:15 PM, the accused picked up quarrel with him, dragged his shirt, torn the same, kicked him by abusing in filthy language, and caused hurt. He was immediately shifted to the community health center Bantwala, where he has taken treatment as an outpatient. Therefore, he requested. It is also stated that the accused had abused him by referring to his caste and thereby committed the offense as stated above. Based on the first information, the FIR was deemed to be registered in crime number 241 of 2014 of Bandwara Rural Police Station, and the investigation was undertaken. The investigating officer filed the charge sheet against the accused. Special CC was registered. The accused appeared before the trial court, pleaded not guilty. The prosecution examined PWs 1 to 9. Got marked exhibit P1 to 11 in support of his contention. The accused has denied all the incriminating materials available on record in a statement under section 313 of CRPC, but has not left any evidence. The trial court, after taking into consideration all these materials on record, came to the conclusion that there is glaring inconsistencies in the evidence led by the prosecution. Therefore, it has failed to prove the guilt of the accused beyond reasonable doubt. Accordingly, the impugned judgment of acquittal was came to be passed. The state has preferred this appeal, being aggrieved by the same. Third source. When counsel for the Leonard HCGP submitted that PW1 is the victim and the first informant. Victim injured and the first informant. PW2 and 3 are the eyewitnesses to the incident. PW3 fully supported the case of the prosecution. PW1 and 3 have deposed consistently, but their evidence is ignored by the trial court. PW4 is the wife of PW1 who took the injured to the hospital. Doctor who examined the injured has given the wound certificate as per exhibit P11 was examined as PW9. If all these materials on record are taken into consideration, the prosecution is successful in proving the guilt of the accused beyond reasonable doubt. But the trial court committed an error in acquitting the accused, according which he prays for admitting the guilt and to allow the same in the interest of justice. To read the materials, including trial court records. At the stage of admission, point for consideration, my answer to the above point in it. It is the specific contention of the prosecution that the accused had a picked up quarrel with the PW1 and abused him in Hindi language by referring to his caste and also assaulted him, as a result of which he sustained injuries. As per wound certificate exhibit P11, the injured had sustained 3 injuries. Injury number 1 and 2 are the tenderness with pain, and injury number 2 is an abrasion over the upper lip, inside the upper lip. The doctor who examined the injured and issued the wound certificate deposed before the court as PW9. During cross-examination, witness stated that injury number 2 mentioned in the wound certificate could be caused if a person falls down on the rough surface. He states that if the injuries were fresh, he would have mentioned so in the wound certificate. but no such mentioning in the own certificate. Next. PW2, even though cited as eyewitness, has not supported the case of the prosecution. There is no reason for him for not supporting the case of the prosecution. PW3, even though supported the case of the prosecution, he deposed that he is a tailor by profession and he was in the shop. He further states that he does not know about the incident personally. Under such circumstances, much importance cannot be given to the evidence deposed by the witness. When the evidence of PW2 and 3 are not helpful to the prosecution, it is only the version of the injured informant PW1 which is before the court. The materials on record discloses that PW1 was having ill will against the brother-in-law of the accused. It is also elicited from the witnesses that PW1 is a drunkard. If these materials on record are taken into consideration in the light of the nature of injury mentioned in Exhibit 11, I am of the opinion that reasonable doubt regarding commission of the offense will arise. Next paragraph. The trial court, after taking into consideration the oral and documentary evidence raised before it, came to the conclusion that the prosecution is not successful in proving the guilt of the accused beyond reasonable doubt, and the evidence of PWs 1 to 3 cannot be believed. I do not find any reason to reverse the finding recorded by the trial court, as it cannot be said that it is either illegal or perverse. The opinion expressed by the trial court is based on the materials that are placed before it. In such circumstances, the appellant has not made out any ground to interfere with the appeal. Accordingly, I will answer the above point in the negative and proceed to pass the following. Appeal dismissed. Send back trial court orders. Appeal dismissed.
Serial number 39, O Shivram Bhatt, Vachan.
The Lordship has heard this matter for some time on the other day, my lord,
Okay.
and dictated the orders.
Huh?
The
Respondent appeared, served absent alone. Again, either no. Then counsel for the appellant is present and submits that he has already addressed his appeal. The respondent is absent. Order sheet dated 6/11/2024 reads as under. In spite of that, when counsel for the respondent is absent, issue NBW against the respondent. If in case of execution of the warrant, respondent is directed to be produced before so and so and so. Next, list for further hearing after execution of the warrant. Issue NBW against respondent.
Yes.
Yes.
Serial number 40, Ashwini Saladi.
Lord, returnable by your.
I have that date code. Yes.
Lords, appear for the appellant, my lord.
Yes.
Lords, there's a delay of 216 days, my lord, in filing the appeal. My lord, your lordships directed me to file a better affidavit, my lord.
Hmm.
Lords, administrative reasons are assigned, my lord.
Then make out a ground on merits of the case.
Please, my lord. My lord, the accused number 1, my lords, was working as a first division assistant in KIDB, my lord.
Hmm? Okay. FDA in?
KIDB, my lord.
Hmm.
My lord, the second respondent accused, my lord, was working as a special land acquisition officer.
Accused number 2.
2, my lord.
Hmm.
My lords, the allegation, my lords, is, my lords, that an illegal gratification of 1 lakh rupees was demanded by the accused number 1, my lord. For my lords, furnishing of a TDS certificate in respect of compensation amount, my lords, that was determined by the KIDB. My lord, this is relating to the BMRCL work, my lord, the metro work, which the KIDB undertakes on behalf of the BMRCL.
Why they were acquitted?
My lords, the trial court holds, my lord. My lords, the allegation, my lords, is under section 7, 13(1)(d) and section 13(2) of the Prevention of Corruption Act, my lord. Lords, as far as section 7 is concerned, my lord, the honorable judge holds, my lord, that we have not been able to, the prosecution has not been able to establish demand, my lord.
Who speaks about demand?
Demand, my lords, my lords, all the witnesses have turned hostile, my lord. In fact, the material witnesses are
Who is PW1?
PW1, my lords, is the shadow witness.
Shadow witness.
Please, my lord. PW2 is the co-master witness, my lord. And PW8, my lords, is the investigation officer.
What about complainant?
My lords, complainant, my lord, the complainant is examined as PW5, my lords. My lord, she says, my lord, that there was no demand, my lords, and
Complainant has not supported.
complainant is not supported.
What about shadow witness?
Shadow witness also, my lord, not supported.
Then is there?
Please, my lord. And my lords, permit me to make one submission, my lord. The accused number 2, my lord, there was a departmental inquiry conducted by the Honorable Lokayukta institution. He has been acquitted, my lord. In
Against accused number 2.
2, my lord.
Then who is PW3?
Lord, PW3, my lord, is one Lakshmi, my lord. My lord, she is also an employee of the KIDB. And PW4, Shankarappa, my lord, they have also turned hostile, my lord.
PW4.
4, my lord, T. Shankarappa.
Employee.
He is also employee, my lord.
3 and 4 of hostile.
Please, my lord, they have turned hostile.
Then 5, 6.
5, my lord.
Is the doctor.
Doctor 6 is Dr. Reju, my lord. 7, my lord, T. Shambat. Material witnesses are 1, 2, and 8, my lord.
When demand and acceptance is not
My lord, what happened was raid was conducted, and my lords, 1 lakh rupees was found in the possession of the first accused, my lord. The second accused, my lord, the witnesses, my lord, they deposed that he was neither, my lord, present at the spot, my lords, nor any demand was made by the accused number 2. Only in respect of accused number 1, my lord, 1 lakh rupees was seized from his right side rear pocket of his pant, my lord.
Even then demand and acceptance.
And then demand is not proved, my lord. That is what the honorable judge says, my lord.
Dispose of.
Please. Lordships could kindly consider, my lord, condoning the delay, my lord, kindly.
Huh?
Kindly.
What is that?
Kindly condone the delay, my lord, if your lordships
Delay
could
condoned,
consider.
but on
Please.
merits disposed of.
Please, my lord. Please.
The state represented by Lokayukta police record this appeal, impugning the judgment dated 21st October 2021, acquitting respondent number 1 and 2 of the offence punishable under section 7, 13(1)(d), that is section 13(2) of Prevention of Corruption Act, coupled with read with section 120B of IPC. The facts of the case are that accused number 1 was working as a first division assistant in the office of Special Land Acquisition Officer, AADB, Gandhinagar, Bengaluru. Accused number 2 was the Special Land Acquisition Officer in the said office. It is alleged that accused number 1 and 2 have demanded illegal gratification of rupees 1 lakh from PW5 for issuance of TDS certificate in respect of the compensation amount awarded for having acquired the land belonging to him under the metro rail project. Stated that accused number 1 and 2 have demanded the illegal gratification on 28/6/2010 to show the official favor, upon which PW5 filed the first information. Pre-trap Panchanama was drawn. The currency notes were entrusted to PW5 in the presence of the punch witnesses. It is the further contention of the prosecution that when PW5 went and met accused number 1 in his office, he again demanded the illegal gratification and accepted the tainted amount for himself and also for accused number 2. On receiving the signal, the investigating officer with the co-punch came to the spot, held a raid. Tainted amount was recovered from the possession of accused number 1. Thus, it is contended that accused number 1 and 2 have committed the offense as stated above. The pre-trap Panchanama, trap Panchanama procedures were conducted, and after completing investigation, the investigating officer has filed the quashing. Next paragraph. The accused has appeared before the trial court, and pleaded not guilty. The prosecution examined PWs 1 to 12, dot mark, exhibit P1 to 36, identified memos 1 to 17 in support of its contention. The accused has denied all the incriminating materials available on record and also examined himself as DW1. He got marked exhibit D1 and 2 in support of his defense. Upon consideration of all these materials on record, the trial court came to the conclusion that the prosecution is not successful in proving the guilt of the accused beyond reasonable doubt. Accordingly, the impugned judgment of acquittal came to be passed. Being aggrieved by the same, the state represented by Local Police is before this court. Since there is delay of 216 days in preparing the appeal, IA 1 of 2023 was came to be filed. What is the reason assigned?
Lots of administrative reasons, my lord.
He stated that since the appellant is a public office, due to administrative reasons, there is a delay in preferring the appeal. Third, so and so. Another so and so. Submitted that. PW5 as complainant filed the complaint, making specific allegations regarding demand of illegal gratification of rupees 1 lakh by accused number 1 and 2. Accused number 1 was working as the FDA, while accused number 2 was the special land acquisition officer in the office of AIDB. These accused were responsible for issuance of TDS certificate in respect of the compensation amount awarded for having acquired the land belonging to PW5. These facts are never disputed by the accused. PW5, the complainant, has not supported the case of the prosecution for the reasons best known to him. The shadow witness is examined as PW1. However, he has not chosen to support the case of the prosecution. But however, there are sufficient materials to prove demand and acceptance of illegal gratification. Admittedly, the tainted amount of ₹1 lakh was found in possession of accused number 1, and the same was seized under the trap Panchanama. In spite of that, the trial court acquitted both the accused without any reason. Hence, the place for allowing the appeal in the interest of justice. And counsel submitted that since the appellant is a public office, there was delay in preferring the appeal, and the same is reasonably explained in the affidavit accompanying the application. Hence, praise for allowing the application and condoning the delay of 216 days in preferring the appeal. Review the materials, including the trial court records. Point for consideration: 1 IA gave whether IA sufficient grounds are made out to allow IA 1 of 2023. Allow the appeal level. Second law. My answer to the above point, point number 1 is in the affirmative, 2 in the negative for the following reasons. It is the contention of the prosecution that accused number 1 and 2 are public servants, as they were working as a FDA and a special land acquisition officer in the office of KIDB. This fact is now never disputed by the accused. It is the further contention of the prosecution that the accused were responsible for issuance of TDS certificate in respect of the compensation amount awarded for having acquired the land of PW5. Even though this fact was disputed by the accused and contended that no official work was pending with them. It is the contention of the prosecution that the accused demanded illegal gratification of ₹1 lakh and accused number 1 accepted the same for himself and also on behalf of accused number 2. It is further contention of the prosecution that the tainted amount received by accused number 1 was found in his possession, and the same was recovered under the trap Panchanama. Next, to prove its contention, the prosecution examined the complainant as PW5 and shadow witness as PW1. Both these witnesses have not supported the case of the prosecution. Nothing has been elicited from them to disbelieve their version. There are absolutely no reason for the witnesses to not support the case of the prosecution. The other witnesses are only the circumstantial witnesses who do not speak about either demand or acceptance of the illegal gratification. It is the settled proposition of law that mere recovery of the tainted amount from the possession of the accused will not prove the demand and acceptance of illegal gratification. When such material fact of demand and acceptance of illegal gratification is not proved by the prosecution, I'm of opinion that prosecution shall fail. I've gone through the interim judgment of acquittal passed by the trial court. The trial court has considered the oral and documentary evidence placed before it in proper perspective and has arrived at a conclusion that the prosecution has failed to prove the guilt of the accused beyond reasonable doubt. It is also brought to the notice of the court that the departmental inquiry was initiated. It was also brought to the notice of the court that departmental inquiry was initiated against accused number 2, in which he was exonerated. Viewed from any angle, I do not find any reason to form a different opinion, and it cannot be said that the impugned judgment suffers from either illegality or perversity. Under such circumstances, I answer point number 2 in the negative. First, point number 1 appellant has filed the IA under Section 5 of Limitation Act, seeking condonation of delay of 216 days in preparing the appeal. In the affidavit accompanying the application, appellant stated that due to administrative reasons, there was a delay of 216 days in preparing the appeal. The reasons assigned in the affidavit could be accepted, as the appellant will not going to gain anything by preferring the appeal belatedly. The only thing that could be done if the application is allowed by condoning the delay is that the appellant could be heard on merits. Hence, I am of the opinion that the delay of 216 days in preparing the appeal should be condoned, as it is not either deliberate or intentional. Accordingly, I answer point number 1 in the affirmative. IA number 1 of 2023 is accordingly allowed. And first in Madi, next Madi. In view of the above, the application IA 1 of 2023 is allowed. Appeal is dismissed. Send back the trial court records. Yes, appeal is dismissed.
Great.
Serial number 41, Venkatesh Soma Reddy.
Let's kindly pass over.
New Year.
Senior is engaged in another.
You are representing whom? Huh?
Respondent.
ಅದನ್ನ
Respondent.
ಹೇಳ್ಬೇಕಲ್ವಾ? ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ ನೀವು
Correspondent.
ಯಾರು ಅಪಲೆಂಟ್ ಯಾರು? ವೆಂಕಟೇಶ್ ಸೋಮರೆಡ್ಡಿ ಆಗಿದ್ದಾರ? ಎಲ್ಲಿದ್ದಾರೆ? ಬಂದಿಲ್ಲ ಇದ್ರಲ್ಲ.
This matter is not a response for appellant. Venkatesh Soma.
Finally proceeding.
Appellant. One for the petitioner. For the petitioner.
He appears for the petitioner.
Petitioner. For the respondent. Respondent is actually confused.
ನಿಮಗೆ ಯಾರಿಗೆ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತೀನಿ ಅಂತಾನೆ ಗೊತ್ತಿಲ್ಲದೆ ಇದ್ರೆ ಏನ್ ಮಾಡ್ತೀರಿ? ಫೈಲ್ ನಿಮ್ಮ ಹತ್ರ ಇಲ್ವಾ? ಅದನ್ನ ಓಪನ್ ಮಾಡಲ್ವಾ? ಅದನ್ನ ಪ್ರಿಸರ್ವ್ ಮಾಡಿ ಇಟ್ಕೊಳ್ಳೋದು ಕಟ್ಟಿ. ತೆಗೆದ್ರೆ ಓದಿದ್ರೆ ಏನಾದ್ರೂ ಗೊತ್ತಾಗುತ್ತೆ. ಎಸ್, ಗೋ ಹೆಡ್ ವಿತ್ ದಿ ಮ್ಯಾಟರ್. ಈ ಕಡೆ ಬಂದು ನಿಂತ್ಕೊಳ್ಳಿ. ಇಲ್ಲಲ್ವಾ ಅಪಲೆಂಟ್ ಇದೆ.
Senior
serial number 42. Abhayendra, V.L. Kumar.
For the petitioners in this matter, this matter pertains to that 91 notice which has been sent for attachment of the property, the bank account. Now, the facts of the case is, complaint was filed on 4/3/2021.
What complaint?
Complaint which is registered under 406 and 420.
Why there are two petitions?
Now, my lords, one is for the seeking for defreezing of the bank account, and second petition has been filed. The criminal petition has been filed, questioning the charge sheet and the FIR, my lords, wherein I have obtained a stay on the matter.
In the first one, what is your prayer?
My lords, 19/957 of 2022 is for seeking for release of the bank account. In the second matter, my lords, 11702 of 2022 is the criminal petition what I have filed seeking for the quashing of the charge sheet and the FIR, in which I have obtained a stay dated 6/12/2023.
1 minute.
Sorry, my lords.
The offense, 406.
406 and 420, my lords. Complaint dated 4/3/2021. At annexure C of the writ petition 19/957 of 2022. Page 19. Subsequently, an FIR gets registered 4/3 on the same date, 4/3/2021.
Not yet filed.
My lords,
Charge sheet
charge sheet
is
is also filed, my lords. 4/3/2021 is the FIR gets registered. That's at page number 15, my lords, annexure B.
Where is the charge sheet?
Charge sheet at page number 22, annexure D. That is the replica of what the complaint is and the FIR. So, the charge sheet ಮಾಡಿದ್ದಾರೆ.
Where is column number 17? 7, column number 7. Please read column number 7.
ದೋಷಾರೋಪಣ ಪಟ್ಟಿ ಅಂಕಣ ನಂಬರ್ 4ರಲ್ಲಿ ನಮೂದಿಸಿರುವ ಆರೋಪಿಯ ಸಾಕ್ಷಿ ನಂಬರ್ 1 ಅವರಿಗೆ ಸಾಕ್ಷಿ ನಂಬರ್ 5 ರವರಿಗೆ ಮುಖಾಂತರ ಪರಿಚಯನಾಗಿದ್ದು ತಾನು ಅಂತಾರಾಷ್ಟ್ರೀಯ ಷೇರು ವ್ಯವಹಾರವನ್ನು ಮನಸ್ ಎ ಫ್ರಾಟಿಕ್ಸ್ ಎಂಬ ಕಂಪನಿ ಹೆಸರಿನಲ್ಲಿ ವ್ಯವಹಾರ ಮಾಡುತ್ತಿರುವುದಾಗಿ ತಿಳಿಸಿದಾಗಿ ಮೇರೆಗೆ ಸಾಕ್ಷಿ 1 ರವರು ಆಸಕ್ತರಾಗಿ ವ್ಯವಹಾರದ ಬಗ್ಗೆ ಮಾತನಾಡಿದ್ದು ಆರೋಪಿಯು ಸಾಕ್ಷಿ 1 ರವರಿಗೆ ಹಣವನ್ನು ತೊಡಗಿಸಿದ ಸರಾಸರಿ 87% ರಷ್ಟು ಲಾಭ ಸಿಗುತ್ತದೆ ಎಂಬುದಾಗಿ ನಂಬಿಸಿ ಐ ಪ್ರಾಫಿಟ್ ಹ್ಯಾಪಿ ಇನ್ವಿಂಗ್ ಎಂಬ ಗ್ರಾಫಿಕ್ಸ್ ಇರುವ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಪೇಜ್ ನಂಬರ್ 23. In essence, the allegation, my lords, is that the allegation is I have invested money.
The remaining portion.
My lords, page number 23, my lords. It's continued there, my lords.
Yes.
May I read, my lords?
Yes.
ಗ್ರಾಫಿಕ್ಸ್ ಇರುವ ಬೆಸ್ಟ್ ಟ್ರೇಡ್ಸ್ ಸತೀಶ್ ಎಂದು ಹೆಸರಿರುವ ಭಿತ್ತಿಪತ್ರವನ್ನು ತೋರಿಸಿದ್ದು ಅವುಗಳನ್ನು ನೋಡಿದ ಸಾಕ್ಷಿ 1 ರವರು ಆತನ ಮಾತುಗಳಿಗೆ ಬೆರಗಾಗಿ ಬೆಂಗಳೂರು ನಗರ ಯಶವಂತಪುರ ಠಾಣೆ ಸರಹದ್ದಿನ ನಮ್ಮ ವಾಸದ ಮನೆಯಾದ ನಂಬರ್ 5 ಇಂಪೀರಿಯಲ್ ನೌಕೇಸ್ ಅಪಾರ್ಟ್ಮೆಂಟ್ ನಂಬರ್ 9 7ನೇ ಮೈನ್ MSR ಕಾಲೇಜ್ ರಸ್ತೆ ಮತ್ತಿಕೆರೆ ಯಶವಂತಪುರ ಬೆಂಗಳೂರು ನಗರ ಎಂಬಲ್ಲಿ ಸಾಕ್ಷಿ 2 ಮತ್ತು ಸಾಕ್ಷಿ 4 ರವರ ಸಮಕ್ಷಮ ಮಾತನಾಡಿ ದಿನಾಂಕ 23/11/2017 ಆರೋಪಿಯನ್ನು ತಮ್ಮ ಮನೆಗೆ ಬರಮಾಡಿಕೊಂಡು ವ್ಯವಹಾರದಲ್ಲಿ ಹಣ ತೊಡಗಿಸುವುದಾಗಿ ತಿಳಿಸಿ ಸಾಕ್ಷಿ 1 ರವರ ಪಂಜಾಬ್ ನ್ಯಾಷನಲ್ ಬ್ಯಾಂಕ್ ನ್ಯೂ BEL ರಸ್ತೆಯ ಅಕೌಂಟ್ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ರಿಂದ ಮತ್ತು ಸಾಕ್ಷಿ 4 ರವರ ಅಕೌಂಟ್ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ರಿಂದ ಆರೋಪಿಯ ಆಕ್ಸಿಸ್ ಬ್ಯಾಂಕ್ ವಿದ್ಯಾರಣ್ಯಪುರ ಶಾಖೆಯ ಅಕೌಂಟ್ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋಗೆ ವಿವಿಧ ದಿನಾಂಕಗಳಂದು RTGS ಮುಖಾಂತರ ಒಟ್ಟು 44 ಲಕ್ಷ ರೂಪಾಯಿಗಳನ್ನು ಕಳುಹಿಸಿದ್ದು, ಹಣವನ್ನು ಪಡೆದು ಆರೋಪಿಯು ಸಾಕ್ಷಿ 1 ರವರಿಗೆ ಸುಮಾರು 1 ವರ್ಷಗಳ ಕಾಲ ಲಾಭಾಂಶವೆಂದು ಹೇಳಿ ಸುಮಾರು 12 ಲಕ್ಷಗಳ ರೂಪಾಯಿಗಳನ್ನು ನೀಡಿದ್ದು, ನಂತರ ಆರೋಪಿಯು ಹಲವಾರು ಸಬೂಬುಗಳನ್ನು ಹೇಳಿಕೊಂಡು ಅವರಿಗೆ ಹಣವನ್ನು ಕೊಡದೆ ಸತಾಯಿಸಿದ್ದು. ಈ ಬಗ್ಗೆ ಕೇಳಿದಾಗ ದಿನಾಂಕ 31/5/2019 44 ಲಕ್ಷ ರೂಪಾಯಿಗಳಿಗೆ ಆನ್ ಡಿಮ್ಯಾಂಡ್ ಅನ್ನು ಕೊಟ್ಟು ನಂತರ ಹಣವನ್ನು ನೀಡದೆ ನಂಬಿಕೆ ದ್ರೋಹವನ್ನು ಎಸಗಿ ಮೋಸ ಮಾಡಿರುವುದು ಲಭ್ಯವಾಗಿ ಸಾಕ್ಷ್ಯಾಧಾರಗಳಿಂದ ಸಾಬೀತಾಗಿದೆ. The allegation is he has given money for investment in shares.
Yes.
Now that 12 lakhs has already been returned. Now, my lords, kindly note, my lords, this is an investment. This is not a loan which has been given. Shares ಅಲ್ಲಿ ಇನ್ವೆಸ್ಟ್ ಮಾಡಬೇಕು ಅಂತ ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದವ್ರಿಗೆ. So they have given money, 12 lakhs ಕೊಟ್ಟಿದ್ದಾರೆ ವಾಪಸ್ಸು.
Yes.
Then subsequently he asked for some more money. He told ನನಗೆ ಲಾಸ್ ಆಗಿದೆ ಕೊಡಕ್ಕಾಗ್ತಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಇದರಲ್ಲಿ. So since that money was not given, he told, okay, fine, you gave me a promissory note. Promissory note was also given. After giving a promissory note, the promissory note was not enforced, and he goes and files a complaint under 406 and 420, and the police registers a case under 406 and 420. Now the police also does an investigation similar whatever has been fact stated in the complaint FIR, they replicated in the charge sheet. Because at the end of the day, this is an investment made. This is not a loan given for him to ask, and there is no deception from the beginning at all. He also knew. This is one part. My lords, on this basis, charge sheet has been filed, and on 8/3/2021, my lords, Annexure E of the petition 19/957 of 2022, 91 notice is been given with the police.
Page number?
24, my lords. '91 notice has been given, and the bank accounts is attached. And subsequently, I file in 451, 457 application before the trial court. That gets rejected. Vide order dated 12/8/2022.
Yes.
At Annexure A, page number 11. At Annexure A, page number 11.
What is the reason assigned?
Reason assigned is page number 8, my lords. The same thing what has been mentioned in the charge sheet, my lords, if I may permit it to read. Right. Page number 13, my lords, is the reason.
Yes.
May I read, my lords?
No, I read it.
So therefore, my lords, 91 notice ಕಳಿಸ್ತಾರೆ. 91 notice ಅಲ್ಲಿ ಅಕೌಂಟ್ ಅಟ್ಯಾಚ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಇವಾಗ. ಆಮೇಲೆ ಇದನ್ನ ನಾನು ಕ್ವಶನ್ ಮಾಡಿ ಬಂದಿದ್ದೀನಿ ಈ ಪಿಟಿಷನ್ ಅಲ್ಲಿ. I filed a criminal petition of 11702 of 2022, my lords. That is a criminal petition questioning the charge sheet. In that, my lords, interim order has been given on, stay has been given on the
Which case?
11702, my lords. That is the criminal petition case.
11702.
That is the second one, my lords. It is attached to this. Yes. In that, my lords, where I have questioned the charge sheet, that I have obtained an interim order dated 6/12/2023.
Further proceeding.
Further proceedings, and that, my lords, if my lords may kindly peruse that order, my lords, since it has been, I'll just read it out, my lords. Adralli specific ಆಗಿ ಬರ್ದಿದ್ದಾರೆ 6/12/2023.
Yes, I am having it. Yes.
Counsel submission accepted, office objection overruled. Learned counsel for the petitioner submits that the allegation made against the petitioner is that the assurance given with the petitioner that the profit to the extent of 87% would be given on the investment made in the international share market. The de facto complainant made an investment of 44 lakhs, out of which 12 lakhs were returned, and for the balance amount, petitioner executed a promissory note in favor of the de facto my lords?
What is all your contention?
No. Thereafter, my lords, finally, my lords. And the petitioner having not paid the balance due for the de facto complainant. He submits that the investment was made in 2017 and the FIR was lodged in 2021. He further submits that in the absence of any allegation that the petitioner induced the de facto complainant to invest in the international share market with an intention to cheat, the essential element to constitute an offense of cheating is absent. Interim order has been granted. Now, my lords, my
submission was considered.
Yes, my lords. No, my lords. My submission, my lords, there are 2 petitions in this. One is with regard to questioning the.
I understood that.
Yeah, my lords. Now, my lords, the attachment agide property adu ನನ್ನ ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ 19/957 ಅಲ್ಲಿ that may be released, my lords. 91 ಅಲ್ಲಿ ಅಟ್ಯಾಚ್ ಮಾಡಿದ್ದಾರೆ.
Yes, ಈಗ notice complete ಆಗಿದೆ.
A respondent is not coming.
Either already represented. Yes, what is
Your Lordship's power is for the, in the writ petition, Your Lordship's power of the police is under section 102, Your Lordships, of the CRPC.
But notice under 91 was issued.
91 is issued, Your Lordships. Notice under section 102 of the CRPC is to be.
No such notice.
The
was
power of
issued.
the police is under section 102 of the CRPC.
No notice under 102 was issued.
No, Your Lordships. It was issued under section 91 of the CRPC.
Similar case, I have produced the citation also of this honorable court, my lords.
That is seizure of the property.
Bank account.
Yes. Section 102.
Please,
Power of police officer to seize
documents.
Documents or things.
whether it will authorize them to freeze.
No,
No,
Your
no.
Lordships. 91, it does not allow your.
102.
No, 102 also they have not initiated. Straight away 91 ಪಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Your Lordships, 102, they have not at all issued notice under 102 at all, Your Lordships, under section 91.
Whether 102 authorizes the police officer to freeze their.
Please, Your Lordships, it does authorize.
So,
Your Lordships, in respect of the criminal petition that is filed, Your Lordships, the complaint may be seen, Your Lordships, where the complainant has clearly alleged that it was the petitioner who has.
he invested the amount in
Please,
shares.
Your Lordships, it was on the inducement of the present petitioner that he has induced the amount. Your Lordships may kindly see the complaint.
Actually, while investing, they will say their lucrative returns will be there.
Please, Your
Can it be
Lordships.
termed as inducement?
Your Lordships, inducing that there will be 87%. Your Lordships, it's not that the complainant had approached the petitioner. It's a petitioner who had approached the complainant, went and visited in.
And if the accused has approached,
Please,
he
Your
should have
Lordships.
some common sense.
Your
And he
Lordships,
has issued, admittedly, he has issued on-demand promissory note.
please, Your Lordships, 87%.
Civil litigation altogether.
Your Lordships, there are records, WhatsApp chat records, which is part of
Let
the
it be there,
investigation.
everything will be there.
Please, Your
Where is the
Lordships.
question of 406 and 420?
Lordships, 420 is where he has induced that there will, you will,
Clear case of investment in shares and securities.
please, Your Lordships. But Your Lordships,
Go before the civil court, recover the amount.
Your Lordships, in the
Not
complainant.
6 420 Elber.
Lordships, the complaint, in his complaint has clearly stated that it was the accused who had approached him.
Let him say, but on perusal of the materials on record, it is a clear case of investment made by the complainant. Of course, at the instance of the accused.
Please, Your Lordships.
How that will give rise to 406 and 420? There must be an intention at the beginning.
Your Lordships, in his,
About how many years back? Investment,
Well, this investment was made in 2017, my lords. From 2017 onwards, he kept on investing.
for 1 year.
Up to
even
18.
According to the complainant, he has given the returns.
At 12 lakhs also ಕೊಟ್ಬಿಟ್ಟಿದೀವಿ ನಾವು.
he has got the returns, Your Lordships. It's only after some time, Your Lordships, when the petitioner. Lordships, there are,
Let's say my submission, page number 21, my
1
lords.
minute, sir. You have finished your submission.
Please, my lord. Sorry,
You
my
should
lords.
keep quiet.
Sorry. my lord.
there are conversations, Your Lordships, chat records, which clearly shows that the petitioner himself says that he's under severe loss and he's under stress to repay the amount.
Criminal breach of trust. Who commits criminal breach of trust shall be punished. To constitute criminal breach of trust,
Please, Your Lordships.
cheating, there must be an intention at the beginning.
Please, Your Lordships.
Entrustment, of course, it is there.
Entrustment is there. Your
Where is the intention at the inception?
Lordship's intention at the inception is itself, your lordship, shows that 87%. He says
If there was an
87%
intention,
profit.
if there was an intention at the beginning,
Please, your lordship.
would he repay 12 lakhs?
Your lordships, that is the whole part, your lordships. Initially, the payments are made. Your lordships, most of these financial frauds, initially they make the payments in the first year, your lordships,
What
to
are the
induce,
chats?
your lordships, to induce the complainant to further
What are
invest.
the
in the-
materials that are produced before, produced by the investigating officer?
Your lordships, there are checks that have been produced, your lordships, and also the statements, conversations between the petitioner and the
conversation?
complainant. Your lordships, in
Conversation?
financial frauds, your lordships, first year they'll give profits to the complainant to induce them to further invest, your lordships. Or else if if the complainant don't see any kind of profit coming towards them in the first year itself or in the first few months, your lordships, they will stop payment. The complainant will stop. Lordships, for
Madam,
that
please-
reason,
Please tell me,
please, your lordships.
the intention to cheat must be at the inception.
At the
You
inception.
You agree with that?
Please, your lordships.
Is it the contention of the complainant?
Your lordships,
Has he stated in the complaint?
lordships, the contention is that, lordships, it was the accused who came to my house. He spoke about 87% interest. This is the profit that you will be getting after investment. Looking into that, your lordships, inducing the complainant has invested around 44 lakhs of amount.
Is there any material to substantiate that?
Your lordships, the checks that have been given to the petitioner's account, your lordships, the bank transactions are there, the
That is
checks are
investment.
there.
Investment is proved.
Please, your lordships. Your lordships, the concept of cheating, your lordships, there can't be any material that can be produced, your lordships. It is the mind of the accused, your lordships.
At least there must be a say.
Lordships, 12 lakhs, 15 lakhs in the first year he is given. Your lordships, the petitioner has paid.
Understand, I am repeatedly asking you, you
Please.
have no answer to that. Requirement of law is there must be an intention to cheat at the beginning, at the inception. Whether the complainant has made such allegations in the complaint, at least.
Your lordships, he says, ಆತನು ನನಗೆ ಹಣವನ್ನು ತೊಡಗಿಸಿದರೆ ಸರಾಸರಿ 87% ಅಷ್ಟು ಲಾಭ ಸಿಗುತ್ತದೆ ಎಂಬುದಾಗಿ ನಂಬಿಸಿ ಆತನು ನನ್ನನ್ನು ಐ ಪ್ರಾಫಿಟ್ ಹ್ಯಾಪಿ ಇನ್ವೆಸ್ಟಿಂಗ್ ಎಂಬ ಆತನ ಮೊಬೈಲ್ ನಂಬರ್ ಇರುವ ಒಂದು ಭಿತ್ತಿ ಪತ್ರವನ್ನು ಮತ್ತು ಫಿಲಿಪ್ಸ್ ಎಂಬ ಗ್ರಾಫಿಕ್ ಇರುವ ಬೆಸ್ಟ್ ರೇಟ್ ಸತೀಶ್ ಎಂಬ ಹೆಸರಿರುವ ಭಿತ್ತಿ ಪತ್ರವನ್ನು ತೋರಿಸಿದ್ದು ಅವುಗಳನ್ನು ನೋಡಿದ ನಾನು ಆತನ ಮಾತುಗಳಿಗೆ ಬೆರಗಾಗಿ ನನ್ನ ಪತ್ನಿಯಾದ ಶ್ರೀಮತಿ ಸುಂತಾರವರೊಂದಿಗೆ ನನ್ನ ಕಾರಿನ ಚಾಲಕನಾದ ಮಂಜುನಾಥ್ ಎಂಬುವನ ಮುಂದೆ ಕುಳಿತು ಮಾತುಕತೆಯಾಡಿ ದಿನಾಂಕ 23/11/2017 ನಾನು ಸತೀಶ್ ಪರಮೇಶ್ವರನ್ನು ನಮ್ಮ ಮನೆಗೆ ಬರಮಾಡಿಕೊಂಡು ನಾನು ನಿಮ್ಮ ವ್ಯವಹಾರದಲ್ಲಿ ಹಣ ತೊಡಗಿಸುವುದಾಗಿ ತಿಳಿಸಿ ನನ್ನ
ಅಷ್ಟೇ,
ಪಂಜಾಬ್
ಅಲ್ಲಿ
ನ್ಯಾಷನಲ್
ಎಲ್ಲೂ
ಬ್ಯಾಂಕ್
ಇಲ್ಲ. He had an intention to cheat ಅನ್ನುವಂಥದ್ದೆಲ್ಲೂ ಹೇಳಿ.
Your lordships, he had approached the complainant only with an intention to cheat. Your lordships, in the
It is to be presumed.
your lordships, it can't be presumed from the complaint. Your lordships, the complainant will not be able to, your lordships, ascertain the intention of the accused. When the accused approaches the complaint, your lordships, it's only when he suffers loss during the course of the transaction, where he stops getting profits accounted to his account. That's when the whole he comes to know that he's being cheated. At the start, your lordships, no accused or no.
There is, according to you, to invoke section 406 and 420, there need not be an intention at the inception.
Your lordships, intention has to be made out from after reading the complaint and the other material, your lordship. Your lordships, the main purpose of the accused for the complainant to invest in his trading, your lordships, is to show inducement that there is 87% interest. And due course, your lordships, in the 1 year or in the 2 years, they will make the profits so that the complainant makes further investments in the account, your
How many
lordships.
witnesses are cited in this?
Please, your lordships.
How many witnesses are cited in the charge sheet?
8. 8 my lords, 8 ಜನ.
Two and 4 are the eyewitnesses.
Please, your lordships.
Who is 3?
Please, Mr. Umesh, will be he was not there at the time of when the talks happened.
Hmm.
Let's one submission, if I may, please, my lord. If I had intention to cheat, I would have not given the promissory note. The issue is this: I have given the promissory note, that has not been enforced. ಅದನ್ನ ಇಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅದನ್ನ ಮಾಡಕ್ಕಾಗಿಲ್ಲ ಅನ್ನೋದು.
To enforce on-demand promissory note, again he has to invest some more lakhs.
That's not. Allah, my lords, I have given the
Already
promissory.
he is fooled.
No, my lords, my submission, my lords, my humble submission is, my lords, investment ಅಂತ ಮಾಡಿದರೆ ನಾವು ಹಾಕಿದೀವಿ. ಹಾಕ್ಬಿಟ್ಟು
7% returns.
My lords, shares ಅಲ್ಲಿ at times if there is a surge in the share market, my lords, I am supposed to get returns. I have not got returns and he is also aware of it. 12 lakhs ಬಂದ ತಕ್ಷಣ ನಾನು 12 lakhs ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀನಿ ಬಿಕಾಸ್ ಇಂಟೆನ್ಷನ್ ಏನು ಇರಲಿಲ್ಲ. ಆ 44 lakhs ಯಾವಾಗ ಕೊಡಕ್ಕಾಗ್ಲಿಲ್ಲ ಅವಾಗ ಹೋಗಿ ಕಂಪ್ಲೇಂಟ್ ಆಗ್ತಾರೆ. ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಮೇಡಮ್ ಪೇಜ್ ನಂಬರ್ 21 my lords, he says, if I may just kindly read, my lords, kindly, my lords. ನಾನು ಅವರನ್ನು ನೀವು ಪೇಜ್ ನಂಬರ್ 20 my lords, the last para, my lords, I'll just read those two paras because that is the effect for which the complaint has been given. If I may read, my lords. ನಾನು ಅವರನ್ನು ನೀವು ಈ ರೀತಿ ನನ್ನಿಂದ ಹಣ ಪಡೆದು ಮೋಸ ಮಾಡುತ್ತಿರುವುದು ಸರಿಯಲ್ಲ, ನನಗೆ ಕೊಡಬೇಕಾದ ಹಣವನ್ನು ಕೊಡಿ ಎಂದು ಹೇಳಿದಾಗ ಅವರು ನನಗೆ ಮನೆಗೆ ಬಂದು ದಿನಾಂಕ 31/5/2019 44 ಲಕ್ಷ ರೂಪಾಯಿಗಳಿಗೆ ಆನ್ ಡಿಮ್ಯಾಂಡ್ ಅನ್ನು ಕೊಟ್ಟಿರುತ್ತಾರೆ. ಇದಾದ ನಂತರ ಆತನಿಗೆ ಮತ್ತು ಇನ್ನೊಂದು ಮೊಬೈಲ್ ಮುಖಾಂತರಗಳಿಗೆ ಸಂದೇಶವನ್ನು ರವಾನಿಸಿದಾಗಿ ಹಾಗೂ ನಾನು ಆತನಿಗೆ ಹಣವನ್ನು RTGS ಮುಖಾಂತರ ಕಳುಹಿಸಿದ ಬಗ್ಗೆ ದಾಖಲಾತಿಗಳನ್ನು ಸಹ ಇರುತ್ತವೆ. ನನ್ನಂತೆ ಆತನು ಇನ್ನೂ ಅನೇಕರ ಜನರಿಗೆ ಹಣವನ್ನು ಪಡೆದು ಅವರಿಗೂ ಸಹ ಹಣವನ್ನು ಹಿಂತಿರುಗಿಸದೆ ಮೋಸ ಮಾಡಿ ದಿಸ್ ಇಸ್ ಔಟ್ ಆಫ್ ನೋ ರೆಕಾರ್ಡ್ಸ್. ಬಟ್ ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾ ಮೈ ಲಾರ್ಡ್ಸ್, ಈ ರೀತಿ ನನ್ನನ್ನು ನಂಬಿಸಿ ನನ್ನಿಂದ 44 ಲಕ್ಷ ರೂಪಾಯಿಗಳು ಪಡೆದು we have not obtained 44 lakhs. ಮೋಸ ಮಾಡಿರುವುದು.
He has invested in which shares or debentures?
Not in
Securities.
no, he gave us money and we have invested in certain shares.
That is what?
We have invested in certain shares, sir.
He has not invested in shares or debentures or securities.
No.
It is you who invested it.
Exactly, my lords. I am the investor. I am the share.
Then
No, my lords.
you obtained the amount from them.
I obtained.
Yes.
I got the money and I invested as per his directions only.
Go for trial.
No, my lords. My lords. My submission, my lords, is
Yes.
there is no element of inception in the ಮೋಸ ಮಾಡಬೇಕು ಅಂತ ಏನು ಇಲ್ಲ. It's an investment.
ನಾನು ಹೇಳಿದ್ದೇನೆ
It is not
ಮತ್ತೆ
a loan.
ವಾಪಸ್ ನನಗೆ
ಅಲ್ಲಲ್ಲ, ನಾನು ನನ್ನ submission
submission ಅಲ್ವೇ ಅಲ್ಲ ಅದು.
ಅಲ್ಲಲ್ಲ, I put it in my petition also the same thing, my lords.
Yes.
If there is an intention, I would have accepted. There is no intention. ಇವಾಗ ಶೇರ್ ಮಾರ್ಕೆಟ್ಸ್ ಹಾಕೋದಕ್ಕೆಲ್ಲ ನಾನು ದುಡ್ಡು ವಾಪಸ್ ನಾನು ಕೇಳ್ತಾ ಇದ್ರೆ my lords, if 406, 420,
Was your intention? You would have invested in the name of the complainant.
it is in the name of the complaint. It is not my name.
Where?
No, share markets ಅಲ್ಲಿ.
But I am asking you, you invested in which, through
Amal,
which
the-
account?
Amal,
In whose name?
Those are to be
Whose name?
in his name only. It is not my name.
Yours.
It is not my name.
Where are the?
My lord,
Have you stated so in your petition anywhere?
no, my lords, I cannot invest in my name. It is not my money.
Have you stated so in your?
No, my lords, it is
petition?
his money only. I can open and invest. I cannot invest in my name.
Then why you have issued the on-demand promissory?
That is because he insisted me that you are not giving. So therefore, I gave an on-demand note.
Oh.
He insisted me.
No fool will give that.
He harassed me because it is not a loan. If it were to be a loan, I had a debt to be given to him. It is in the nature of investment. Now, suppose if I invest a money in the company and company loss ಆಯ್ತು ಅಂದ್ಬಿಟ್ಟು ನನ್ನ ಕಂಪನಿ ಮೇಲೆ 406, 420 ಹಾಕಕ್ಕಾಗಲ್ಲ. I lost it because it is in equity. It's investment in equity. Then I have to file a case against all the share brokers.
You have issued blank checks.
ಚೆಕ್ಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದೀನಿ.
Blank check.
ಬ್ಲಾಂಕ್ ಚೆಕ್ಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದೀನಿ and that ಅದನ್ನು ಕೇಸ್ ನಡೆಸ್ತಾ ಇದ್ದಾರೆ.
No, sir, it is a clear case of cheating.
My lords, the ingredients,
Few blank
my lords, in the
checks,
charge
you
sheet, my
issue a
lords,
Promissory note, and you say.
my lords, if
"You're a
they come
share
and
broker."
if they come and harass
No
me,
share broker will do that.
no, if they, my lords,
If he is doing a genuine business.
my lords, they will do it, my lords. The reason is simple. If in every case, if for an investment, if the money is not returned and the case has to be filed, then every case, the brokers, against the brokers, the case will be filed for 406, 420. It is an investment in equity. Kindly, my lords, consider this, my lords.
I am allowing your petition WP 19957 of 2022 and dismissing 11702. First one WP 19957 of 2022. Common order ಮಾಡ್ಕೊಂಡು the petitioner in both these petitions. Petitioner in this petition being the accused in crime number 77 of 2021 of Yeshwanthpura Police Station, registered for the offence punishable under section 406 and 420 of IPC, now pending in CC number 2428 of 2022 on the file of Learned Third Additional Metropolitan Magistrate Bengaluru. He is seeking release the bank account which was freezed by the investigating officer during investigation, and to quash the criminal proceedings initiated against him. The facts of the case are that respondent number 2 had the first information against the accused, making allegations that he has committed the offence under section 4 committed the offence of criminal breach of trust and cheating, punishable under section 406 and 420 of IPC. It is the contention of the complainant that the accused has induced him by proclaiming that he is doing business in the shares and the securities. And if the complainant invests amount, he will get profit of 87%. He has shown some documents proclaiming that he is declared as a document certificate to declare him as a best trader, thus induced the complainant to believe that he will get 87% returns if he invests the amount. Accordingly, the complainant in the presence of CW2 and 4 transferred the amount to the account of the accused through RTGS. It is the further contention of the complainant that initially for 1 year, the accused had paid in all rupees 12 lakhs. But later, he has never paid any amount to the complainant. When demanded, he has issued on-demand promissory note. Thus, it is the contention of the complainant that the accused, with an intention to cheat, received huge amount of rupees 44 lakhs from the complainant, promising to pay rupees, promising to return, promising 87% return, but failed to pay the returns or the principal amount when demanded. Thus, he has committed the offence as stated above. On the basis of the first information, the FIR was came to be registered in crime number 77 of 2021 of Yeshwanthpura Police Station for the aforesaid offence, and the investigation was undertaken. It is stated that during investigation, a notice under section 91 of CRPC was issued, and the bank account of the accused was freezed. Now the investigation is completed, charge sheet is filed for the aforesaid offences. Petitioner being the accused is before this court. WP number 9957 of 2022 to defreeze the bank account, and 11702 of 2022 to quash the criminal proceedings. Third submission. The counsel for the petitioner in both the petitions contended that the petitioner was served with the notice under section 91 of CRPC, which authorizes the investigating officer only to summon the accused for investigation, and it will not authorize him to freeze the bank account. No notice under section 1 or 2 of CRPC was issued and no such procedures were adopted. Under such circumstances, the bank account that was freezed by the investigating officer is to be defreezed. Accordingly, he prays for allowing WP 19957 of 2022. Next part. Then counsel further submitted that the contention of the complainant that there was a criminal breach of trust or cheating has no basis. It is a clear case of investment by the complainant in the shares and debentures. And the returns on the investment will depend upon the trend in the market. Whenever the complainant earned a profit, same was paid to him. But subsequently, when the market was dull, there was no profit. However, the petitioner had issued blank checks in favor of the complainant. He had also issued on-demand promissory notes, which proves the bona fides of the petitioner. No offense under 406 or 420 of IPC is made out, hence the case for allowing the criminal petition number 11702 of 2022 by quashing the criminal proceedings. Per contra, when the HCGP, when an additional SPP opposing the petitions submitted that it is a clear case of criminal breach of trust and cheating by the petitioner. Admittedly, the petitioner had not invested the amount, got invested the amount through the complainant, but he received the amount to his account and in turn paid rupees 12 lakh in all during first year, and thereafter nothing has been paid. Huge sum of 44 lakhs was made to be transferred by the complainant to the account of the petitioner by inducing him, by showing the certificate that he is the best trader and 87% profit will be paid to him. It is a clear case of inducement, criminal breach of trust and cheating. The investigation, charge sheet is filed. CW1 is the informant himself. CW3 and 4 are the eyewitnesses to speak about the inducement by the accused. From the materials that are placed before the court, can be gathered that the petitioner was having an intention to cheat the complainant from the beginning. Under such circumstances, the 11702 of 2022 is liable to be dismissed. When the additional SPP clearly considered that the investigating officer has not issued the notice under section 102 of CRPC, but he had issued the notice under section 91 of CRPC and proceeded to freeze the bank account. Under such circumstances, she pays for passing appropriate orders. Peruse the material, found for consideration minus carried a point money. Can do WP defreeze, can do quashing. Point number 1 in the affirmative, 2 in the negative for the following reasons. It is the specific contention of the petitioner that he was served with the notice under section 91 of CRPC and thereafter freezed his bank account as mentioned in the petition. One could have bank account bearing number 911010004478553. With they have bank account note, Axis Bank, Vidyaranyapura branch, Bengaluru. He was never served with, admittedly, the petitioner is not served with the notice under section 102 of CRPC. Section 91 of CRPC deals with summoning the accused to produce the documents summoning a person to produce the document, other things during investigation or trial. Section 102 of CRPC deals with seizing the power of the police officer to seize certain property. It is the settled proposition of law that the police officer during investigation can invoke section 102 of CRPC and seize the operation of the bank account if such assets have direct link with the commission of the offense. When admittedly the investigating officer had not invoked section 102 nor issued any notice under the said provision of law, he could not have freezed the account of the accused by issuing the notice under section 91 of CRPC, which only enables him to summon the accused for production of any document or other thing. Therefore, I am of the opinion that the freezing of the bank account pertaining to the petitioner is liable to be set aside, and the bank account is required to be defreezed. Accordingly, I am accepting the above point number 1 in the affirmative. Next. Respondent number 2, being the complainant, has filed the first information based on which the FIR was came to be registered. After investigation, the investigating officer filed the charge sheet. Admittedly, the petitioner called upon the complainant to invest in shares and securities. It is the contention of the complainant that the petitioner had promised to pay 87% returns. This fact is stated by the complainant, who is cited as CW1 in the charge sheet, and also by CW2 and 4. These witnesses also state that the petitioner had shown a certificate to induce the complainant that the petitioner is declared as a best trader. From all these facts, the complainant was induced to invest huge amount of ₹44 lakhs, which he transferred to the account of the petitioner through RTGS. Admittedly, the petitioner had not asked the complainant to invest in shares and debentures directly through his account, which gives rise to a reasonable doubt regarding the intention of the petitioner in trading in shares and securities. Moreover, the petitioner himself contends that he had issued on-demand promissory note and also blank checks in favor of the complainant. If at all, the complainant was made to invest in shares and securities. The petitioner, being the share broker, would not have ventured to issue blank checks and on-demand promissory note in favor of the complainant. The conduct of the petitioner give rise to a reasonable doubt which makes out prima facie case in favor of the complainant regarding his contention. Since there are prima facie materials, I am not against the petitioner, I am of the opinion that he is not entitled to the relief of quashing the criminal proceedings initiated against him. Hence, I answered the above point number 2 in the negative and proceed first of all. Petition so and so allowed, found refused. Petition 11702 of 2022 dismissed. Yes.
For argument, serial number 43, Girish DS, KP Jayasimha.
At the time, the negotiable instrument.
Yes.
The judgment of acquittal has been challenged.
You are the complainant.
And
Then admit of it. Admit of it. ಆಗಿದೆ ಫೈನಲ್ ಯಾರು ಅಡ್ವೊಕೇಟ್ KP ಜಯಸಿಂಹ ಇದ್ದಾರೆ. ಅವರಿಗೇನು NBW ಕೊಡೋಣ ಲಾಸ್ಟ್ ಟೈಮ್ ಏನಾಗಿದೆ. Today is absent again. Respondent is absent. Counsel for respondent is absent.
so many times was posted. What happened? Sometimes he appears, sometimes it's not a time.
No, you moved the memo, is it not?
Yeah, I moved.
1 minute, 1 minute, 1 minute. When counsel for the appellant is present, he moved the memo for listing of the case. Accordingly, it is listed. Then counsel for the respondent is absent. It is noticed that initially NBW was issued against the respondent as the counsel representing him was absent. Subsequently, an application under section 70(2) of CRPC was filed. Allowing this said application, the NBW was recalled. When the matter is listed today, again, the learned counsel for the respondent is absent, no representation. The appeal is of the year 2015. I find considerable force in the contention taken by the appellant that deliberately the respondent is evading arguing the matter before this court. Hence, issue NBW against the respondent. In case of execution of through the jurisdictional police with the assistance of the appellant. On executing the NBW, the jurisdictional police is directed to produce him before the jurisdictional magistrate, issue NBW. Next. Assist the police for in executing the warrant.
Yes.
Mr. Reed. Non-compliance of office objection for first time, serial number 1, JM Sharath.
Counsel for the appellant petitioner is absent, no representation. This time.
2, Abdul Rashid.
Absent, no representation.
3, S. Rashekar.
Sitting for the petition.
Pray for this time. Please time. Next.
Orders first time matter, serial number 4 and 5.
Learned HCP takes notice for respondent number so and so. Private either issue notice. Yes.
For order, serial number 6, Moinuddin.
Lord. There is 2 of the petition, I have produced certified copy of the lower court or trial court order saying past and series manner 608 of 24. Happens to be over.
You know, what is that?
Serial number, sir?
6 minutes.
6, it is for orders.
Issue notice ಆಯ್ತಲ್ಲ. Oh,
6, sir.
next.
Serial number 6.
Serial number? 6 for orders. You can argue the matter.
There, my lords.
ಕೊಡಿ.
Petitioner, my lords.
Yes, who is the petitioner?
A3, my lord.
A3.
A3.
When he was arrested?
25/9/2023.
25/9/23. What are the offense? 302.
302, 120B, 109, 427, read with 34 of IPC.
In all, how many accused are there?
My lord, 5 accused, my lord, initially, my lord. The de facto complainant identified A5 and gave the complaint, my lord. But A5 was dropped in the charge sheet, my lord.
In charge sheet, how many accused are there?
4 accused, my lords. My lords,
Yes.
there is a name forthcoming in the complaint.
Is it the first petition?
Yes, please.
Yes.
My lords, this.
What about 1 and 2?
1 and 2 is pending before your lords.
So all are in JC.
Please, my lords.
Accused number 1 to 4 are in JC.
Please, my lords.
Yes.
My lords, the name of the A5 who has been dropped in the charge.
What is the allegation? Where is the charge sheet? Column number 17. Who is the deceased?
This is the son of the de facto complainant. My lord, here, my lord, the name of A5 is named by de facto complainant in the complaint. Subsequently, FIR also shows the name of the.
Sir, ಏನು allegation ಏನು ಅಂತ first ಹೇಳಿ ದಯವಿಟ್ಟು.
That, my lords,
As per charge sheet, what is the allegation made against the accused?
as per the charge sheet, my lords, A5 who was dropped in the charge sheet from charge sheet was attacked, deceased, and succumbed him to death, my lord.
So only accused number 5 was assaulted.
5 and his friends.
Who are there?
My lord, de facto complainant will not identify them, my lord.
Who are the eyewitnesses?
Eyewitness is one watchman, my lord.
CW?
CW 9, 12 and 13 are the eyewitnesses.
Who says that, my lord?
What are the weapon used?
Knife man.
Knife, my lord.
Who are
And
the
was not
assailants?
recovered by a petitioner, my lord.
They are the assailant. He is also an assailant.
Accused number 1 to 4.
He assaulted on the head, chest and other parts of the body.
Almost 1 year and 2 months, my lord, no charge has been taken place. My lord.
PM report, how many injuries?
There are 18 injuries, my lord.
Yearly the page number? You have not produced the PM report?
Produce the PM report.
18 injuries.
18 injuries, my lord, and death is due to.
Where it is in, refer to column number 17, where is the allegation against the present petition?
My lord, page number 54 is the column number
Yes,
70,
got
my
it.
lord. In the second para, my lord, from the bottom, 8th line, my lord, may I read, my lord? ಆರೋಪಿಗಳಾದ 2, 3 ಮತ್ತು 4ರವರುಗಳು ಅಟ್ಟಿಸಿಕೊಂಡು ಬರುತ್ತಿದ್ದುದರಿಂದ ತಪ್ಪಿಸಿಕೊಳ್ಳಲು ಬಾಗಿಲು ತೆರೆದಿದ್ದ ಪ್ರತ್ಯಕ್ಷ ಸಾಕ್ಷಿ 12 ಮತ್ತು 13ರವರ ಮನೆಗೆ ನುಗ್ಗಿದಾಗ 2ನೇ ಆರೋಪಿ ಠಾಣಾ ಮಾಲುಪಟ್ಟೆ ಸಂಖ್ಯೆ ನಲ್ಲಿ ನಮೂದಿಸಿರುವ ಫೋಲ್ಡಿಂಗ್ ಬಟನ್ ಸ್ಟೀಲ್ ಚಾಕುವಿನಿಂದ ಆರೋಪಿಗಳಾದ 3 ಮತ್ತು 4ರವರು ಠಾಣಾ ಮಾಲುಪಟ್ಟಿ ಸೋನ್ಸೋ ನಮೂದಿಸಿರುವ ಮಟನ್ ಕತ್ತರಿಸುವ ಚಾಕುವಿನಿಂದ ತಲೆ, ಎದೆ ಮತ್ತು ದೇಹದ ಮೇಲೆ ಚುಚ್ಚಿ ಮಾರಣಾಂತಿಕ ಹಲ್ಲೆ ಮಾಡಿ ಭಾರೀ ಸ್ವರೂಪದ ರಕ್ತಗಾಯಪಡಿಸಿ ಪರಾರಿಯಾಗಿರುತ್ತಾರೆ. This is the allegation against the petitioner. There is one more case pending against him, my lord.
My lord, that has not been, that has been settled, my lord. Crime number 50 of 2023 in Wilson Garden case. That has been settled, my lord.
What are the offense alleged in that case?
392, my lord.
392.
Yes, my lord.
This is crime number
This is crime number 199 of 23, my lord.
199 of 2023. No, not entitled, sir. Now what is the stage before the trial court?
HPC.
HPC. Agala. Next.
My lord. My lord. 1 year, 2 months.
ಆಯ್ತು, ಅದೇನ್ ಮಾಡಿ ಅವನು ಹೋದವನು ಬರ್ತಾನ ವಾಪಸ್ಸು 1 year 2 months ಆದ ಕೂಡಲೇ.
My lord, the witness will not specifically states that the petitioner
ಅಲ್ಲಿ ಆಗ್ಬೇಕು ಅವ್ರು.
I may be having the liberty to file a bail application on the charge sheet, my lord.
No, no, no.
At the crime, at the
Insist the trial court, go before the trial court, say that you have no hearing before charge. The court will frame the charge. Thereafter, the prosecution will examine the witnesses. You are not allowing the trial court to frame the charge. And here you say long incarceration. You cannot take advantage of your own wrong. Go before the trial court, insist for framing charge.
Criminal May 608 of 24 came to be rejected on the trial number. Their charge sheet was not
Yes,
placed.
yes, yes.
Now charge sheet is filed, my lord.
Merely because,
Lords have-
see, filing of charge sheet will further strengthen the case of the prosecution. It will not inure to your benefit. ತಗೊಳ್ಳಿ. Petitioner being case number 3. is
At
seeking
least may
grant of
have the liberty to
bail.
withdraw and come after the evidence, my lord.
After the evidence, ಅದು trial court consider ಮಾಡುತ್ತೆ. You are withdrawing it. Then
Yes.
counsel for the petitioner after addressing the argument at length seeks permission to withdraw the petition as not rest with liberty to approach the trial court after examination of the witnesses. Submission is accepted, petition dismissed as withdrawn with liberty as paid.
Serial number 7, JNTR.
Serial witnesses.
Appearing for petitioner, my lords. This is a successive bail petition, my lords.
Who is the
All-
petitioner?
My lords.
Petitioner is,
Accused number 1, my lords.
all how many accused?
4 accused number, my lords. Accused number 4 is absconding since the case has been split up against accused number 4, my lords.
When the petitioner was arrested?
8/1/2024, my lords.
What of the offense?
307, 109, 120B, read with 34 of IPC, my lords.
What about other accused?
My lords, against accused number 1, 2, 3, the charge has been framed
No, accused number 2 and 3.
in judicial custody.
They are in
sir.
this.
Judicial custody.
Now charge is framed.
Please, my lords.
Face the trial. Is it the first petition? Earlier you have approached.
Earlier, we have approached in criminal petition 5510 of 24, my lords, which was rejected on 8/7/2020.
So all the 3 have approached.
Please, my lords.
It was dismissed on merits. Now, what is the change in circumstance?
My lords, charge sheet has been framed.
That will further strengthen, I have already stated.
My lords, there
Filing
is,
of the charge sheet, the investigating officer has placed on record the incriminating materials.
my lords, the motive was only against A4, my lords. There was a rivalry between victim and the accused number 4, my lords. Accused number 1, 2, 3, the present petitioner,
After
they're
filing,
the
after filing
associates
of
of,
the charge sheet, you approach this court.
please, my lords.
That your petition was rejected.
No, my lords.
Huh?
It was in crime stage. Earlier, it was
Crime
in
stage.
crime stage.
No. Read the order. After investigation, charge sheet is filed against accused numbers 1 to 4. It is stated that accused number 4, who was having motive to cause the death of the deceased, is still absconding.
Please, my
Yes,
lords.
that was your contention. That was the observation. So after filing the charge sheet, this is the second petition.
Please, my lord.
Now, you should assign the reason. Considering the nature and seriousness of the offense, the petitioners are not entitled. Yes, dismissed. Same.
My lords, there is no criminal antecedent, my lords.
But
Kindly
then-
one chance may
Even
be
then, on
granted.
merits, it is already dismissed amount. Even after filing the charge sheet. Assaulted the injured with chopper, machete, knives on his head and caused grievous injury with an intention to kill him. Yes, Tawal. The petitioner, being accused number 1, is seeking grant of bail. He was apprehended on 8/1/2024. Since then, he is in judicial custody. The statement of the injured was recorded while he was taking treatment in the hospital. He has specifically stated the names of accused number 1 to 3 and also referred to another person as the assailants. The injured stated that accused number 4 was having motive to cause his death. After investigation, charge sheet came to be filed against accused number 1 to 4. He stated that it was.
My lord, there are 3 cases against him, my lord, the antecedents.
1 minute, I'll come to that.
Please.
Accused number 4 was having motive to cause the death of the deceased and filed. 1 to 4. It is stated that accused number 4 was having motive to cause the death of the deceased and he is still absconding. A split up charge sheet that have been filed against him. Next para. The materials on record disclose that the injured was immediately after the incident. The injured was shifted to the hospital. He was treated. The wound certificate discloses that he has sustained in all 5 injuries. It is alleged that the accused, including the petitioner, assaulted the injured with chopper, machete and knives on his head and caused grievous injury with an intention to cause his death. The weapons were recovered at the instance of the accused. Next para. It is noticed that the petitioner, along with accused number 2 and 3, had approached this court by filing criminal petition number 5510 of 2024, which was came to be dismissed on merits with an order dated 8th July 2024. There are no change in circumstance to entertain the present petition filed by the petitioner, accused number 1. Next part. Learned HCGP submits that the petitioner is having criminal antecedents as crime number.
Crime number 5 of 22, my lord.
5 of
2022
of
Vivek Nagar Police Station for the offences under section 27B of NDPS Act.
57.
27B
of
NDPS Act. And crime number 318 of 2020.
20.
Ashok Nagar Police Station. The offence is 399 and 402. And crime number 190 of 2020. Ashok Nagar Police Station. Section 307, the Redwood 30.
Are registered against him. And on this count also, the petitioner is not entitled for a grant of bail. Now the matter is that Admittedly, the charge is already framed by the trial court and the matter is set on for evidence. In view of all these facts and circumstances, I am of the opinion that the petitioner is not entitled. Dismissed.
Obliged, my lords.
Serial number 8, Sigdi Veerana.
Petitioner is accused number 4.
Accused number 4.
Yes, ma'am. There are
You know-
totally 4 accused, seven accused, madam. Accused number 2, petitioner is accused number 2.
Huh?
Accused number 2, my lord, petitioner.
When he was arrested?
Pardon, my lord?
When he was arrested?
My lord, he was arrested on 1/4/2024, my lord.
What are the offense?
Offenses, my lord, 511, 120B, 406, 420, 489B and 489C.
What about the other accused?
As far as accused number 3 to 7 are concerned, my lord, your lordship was pleased to grant them bail.
One, what about
And pardon, my lord,
one?
1 and 2 are in custody. my lord. 1 and the present petitioner are in custody.
Hmm.
And my earlier petition, my lord, was withdrawn, which your lordship will find on page number 137, my lord.
Yes.
It was at the crime stage.
Now charge sheet is filed.
Charge sheet is filed, my lord. Nothing is recovered from me, my lord.
Where is the charge sheet column number, sir?
Yes, my lord. Your lordship will find on page number 59, my lord.
What is the allegation against this
Sir,
petitioner?
as far as the allegation against me is, my lord, I tried to persuade the complainant to hand over me 25 lakhs rupees on the promise that I will give them black money of rupees 100 crores. 1 crore.
Hmm.
Of course, no money was paid by the complainant to me. It is only an attempt as far as the complaint is concerned. Only 511. But the charge sheet material shows that, my lord, I have received rupees 8,50,000 from Dr. Busnoor, Rajshekhar Busnoor Mat, and an amount of rupees 17 lakhs from Dr. Sri Harsha. my lord.
That was paid to?
Pardon, my lord?
That
Pa-
was paid to?
Paid to petitioner. my
How much?
lord. Dr. Busnoor Mat ಅವರು 15 ಲಕ್ಷ, sorry, 8.5 lakhs. And Dr. Sri Harsha, 17 lakhs. As far as section, my lord,
Allegations in the relevant portion.
my lord, your last 4 lines in the charge sheet, my lord. 5 lines from the. A1 ಆರೋಪಿ ನಿರ್ದೇಶನದ A2 to 7 ರವರೆಗೆ ಎಲ್ಲ ಆರೋಪಿಗಳು ಕೂಡಿ ಸಾಕ್ಷ್ಯ ನಂಬಿಸಿ ಸಾಕ್ಷಿದಾರರಾದ ರಾಜಶೇಖರ್ ಬೂಸ್ನೂರ್ ಮಠ್ ಡಾಕ್ಟರ್ ಹರೀಶ್ ರವರಿಗೆ 8 ಲಕ್ಷ ಮತ್ತು 17 ಲಕ್ಷ.
What happened to this amount?
Pardon, my lord?
Whether this amount was recovered?
Nothing is recovered from me.
Nothing recovered.
Nothing is recovered from me.
Yes.
The recovery is from A1, my lord.
Clarity.
Yes, my lord, but I want to make few submissions, my lord. With respect of accused number 2, my lord, it is in the complaint, my lord, he has been named in the complaint and he actively participated in the crime, my lord. And my lord, one mobile phone of this petitioner was recovered, wherein, my lord, the WhatsApp messages and the phone calls with the other accused and with the A1, my lord. And also, there are certain photographs, my lord, wherein the fake notes were taken photograph with the accused number 2, my lord. And one notebook was seized from the premises of the accused number 1, my lord, in which, my lord, it is shown is the name, my lord, that several amounts have been received from him, my lord. From this petitioner, that notebook shows that, my lord. And there are 2 other cases against him, my lord, under section 79 and 80 of the KP Act.
2 other cases.
Yes, ma'am.
Under
79 and 80 of the KP Act, my lord. Crime number 48 of 2000. KP Act.
Both KP Act.
Both KP Act. Yes.
KP Act, my lord.
materials, sir.
Pardon, my lord?
There are materials against you.
No, but your lordship,
Mobile phone
yes, but your,
contains some
yes, your
incriminating.
lordship may kindly see, my lord, none of the offences are exclusively punishable with death or imprisonment for life. Apart from that, my lord, I have also produced my health condition. Your lordship may kindly come to page number 92.
No, you have to choose either you are seeking bail on medical grounds.
That's also additional ground.
Oh,
That,
you know.
because when I filed earlier, charge sheet was not filed. The charge sheet is now filed. And none of the offences alleged against me are exclusively punishable with death or imprisonment for life. And as far as section 489B and 489C are concerned, my lord, they are not applicable to me because from my position.
Why? Your name is initially mentioned by the complainant.
Yes, in the
Mobile phone
complaint
contains the
is-
incriminating
yes.
materials.
And my lord, your lordship may kindly.
Even the notebook
Yes.
found in the premises of accused number 1.
Yes, but your lordship may kindly,
Your name.
your lordship may kindly consider that if any of the offences were exclusively punishable with death or imprisonment for life, my lord, generally your lordship may kindly see there can be some restrictions on granting bail. And secondly, my lord, your lordship may kindly see this 437 CRPC is applicable, my lord, your lordship may kindly see the bail is generally granted. 437, but
Yes.
as far as I am concerned, because since 489 and 489 section is not
ಅದೆಲ್ಲ
applicable.
ಬರಲ್ಲ ಇವಾಗ ಎಲ್ಲದಕ್ಕೂ ಬರುತ್ತೆ ನಿಮ್ಗೆ.
And then your lordship may kindly see my health condition also may be additional ground, your lordship may kindly.
ಏನದು?
My lord, page number 92. And on page number 94, my lord, triple vesicle, I am suffering from triple vessel disease, heart disease.
ಎಲ್ಲಿದೆ ಅದು?
My lord, on page number 94. Last but one line.
Triple vessel disease. Yes.
Yes, I'm a heart patient, my lord, and I am aged.
Angiography ಆಗಿದೆ.
Pardon, my lord?
Angiogram ಆಗಿದೆ.
After all examination, my lord, that is the finding. And other documents also shows that, my lord, I am suffering from heart ailments.
ಅಲ್ಲೇ ಅವ್ರಿಗೆ ಹೇಳೋಣ.
Heart ailments. And considering the fact, my lord, that I am in custody for more than a year now.
What is the stage?
Hearing before charge. But I'm not very sure because I'm not appearing. Hearing before charge ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ sir, I don't know.
ಇಲ್ಲ. No. ಬಿಡಿ, ತಗೊಳ್ಳಿ. Petitioner being accused number 2. Is seeking grant of bail. He was
Just a
granted
minute,
on
madam.
1/4
1 minute, but just. For the present, my lord, I will withdraw the petition. Lordship may kindly direct the trial court to expedite the trial at least.
Learned counsel
For
for
1
the
year or
petitioner.
6 months or 1 year.
I will not fix the
No.
time frame, sir.
Not.
Seeks permission to withdraw the petition with liberty to renew his prayer after examination of material witnesses.
Or Your Lordship may kindly say that if the trial is not commenced within 6 months, I may be permitted to revive the.
Submission is accepted. Petition is dismissed as not pressed with liberty as prayed for. Trial court is directed to expedite the trial since petitioner is in judicial custody. Yes. Expedite the trial.
Serial number 9, Chandrasekhar.
Lord, on the other day, my learned Karnataka advocate was pleased to mention that there are other crimes. Lord, out of 4 crimes, in 2 crimes, my lord, the order of acquittal is passed. In one case, my lord, the petitioner has been dropped from the charge sheet.
In which case you are acquitted?
Lord, crime 112, CC number 98, 986 of 2016.
Crime number?
Crime number 12 of 2016.
Acquitted?
Yes, acquitted. Crime number 50 of 2016, acquitted. Acquitted means not, he has been in crime number 112, he has been dropped from the charge sheet itself.
112 ಹೇಳಿಲ್ಲ ಅವರು 102 ಅಂತ ಹೇಳಿದ್ರು.
Bari 12, sorry.
12 ನಲ್ಲಿ dropped.
Dropped, charge sheet ನಲ್ಲೇ drop ಮಾಡಿ second accused acquit ಆಗಿದೆ.
Then 50 in 50
ನಲ್ಲಿ acquit ಆಗಿದೆ.
acquitted.
Acquitted.
What about the other?
My lord, in 2 matters, my lord, in one matter, my lord, the charge sheet came to be filed. In fact, my lord, it is a land dispute. My lord, the petitioner, his brother, his sister, and his mother, they have been implicated in that case, my lord. That is going on.
55.
ಅದು ನಡೀತಾ ಇದೆ, but ನಮ್ಗೆ ಇನ್ನೂ ಸ್ವಲ್ಪ ಮಾಹಿತಿ ಸಿಕ್ಕಿಲ್ಲ. The government is the
So
better
admittedly, you are having criminal antecedents.
person. My lord, of course, my lord, I cannot, for the time being,
You cannot deny that.
my lord, for the present case, my lord, on parity ground, my lord, your lordship, after considering the
Rowdy sheeter?
nature of the
Yes, ma'am. That is pending.
rowdy sheeter 9 ವರ್ಷದ
Not
ಹಿಂದೆ
closed,
open
my
ಮಾಡಿರೋದು.
lord.
ಈಗ ಏನಾಗಿದೆ ಅಂತ
Not it closed, my lord. That area.
ಏನಾಗಿದೆ
Not
ಅಂತ
sought for
ಗೊತ್ತಿಲ್ಲ. He
closing.
is also not bothered about the
Yes, that is what he
ಗೊತ್ತೇ
happily
ಇಲ್ಲ ಅವ್ರಿಗೆ.
continues to commit the offense.
No, my lord, 2016, at least I can understand, my lord, he is in the habit of doing the criminal activities. But after
5
2000
criminal cases are registered against him.
ಅಲ್ಲ,
So rowdy sheeter.
16 ಮೇಲೆ 16 ಮೇಲೆ ಅದು 2009 ವರ್ಷದ ಕೆಳಗಡೆನೆ ಆಗಿರೋದು. ಅದಾದ ನಂತರ subsequently, my lord, I can understand, suppose if he commits the same, he repeats the same criminal activity.
2016 in 3 FIRs, 2019 1 FIR,
3 ನಲ್ಲಿ ಅದರಲ್ಲಿ 2ರಲ್ಲಿ ಅಕ್ವಿಟ್ ಆಗಿದೆ.
then 2024 1 FIR.
ಇದು ಪ್ರೆಸೆಂಟ್. ಇದು ಪ್ರೆಸೆಂಟ್.
Continues to commit the offense. That is what I am saying.
By provoke, my lord, it has been happened.
ಎಲ್ಲದರಲ್ಲೂ ಅದೇ sir.
But
Do you admit that any of the offense were committed by you?
I cannot. With any stringent condition on
No-
parity ground.
No
The other
condition will
accused, my lord,
deter you,
A1,
sir.
my lord, your lordship was pleased to grant it the bail by imposing a condition
No,
that, my
sir.
lord, he should not repeat.
No, nothing.
16
Invariably, in all these cases, such conditions were imposed. You can take out the order of
Yes,
the
yes,
granting bail.
that is-
Invariably, that condition will be there.
Yes, yes,
That has
is
not
true.
deterred him from committing the offense.
ಹೌದು. ಇದು ಕೂಡ ಅಕ್ವಿಟ್ ಆಗಿರೋದು 2018 ಅಲ್ಲಿ.
Seek acquittal. ಅಷ್ಟೇ. ತಗೊಳ್ಳಿ.
Lord, on parity ground also, my lord, he is entitled.
It
But
is,
injuries, my lord,
antecedents.
it is a simple in nature. Nothing has been recorded from him. ಇವನ್ ಮೇಲೆ ಅಲಿಗೇಷನ್ ಇರೋದು ಜೋಬುಯಿಂದ ಚಾಕು ತೆಗೆದು ಕೊಟ್ಟ ಅನ್ನೋದು ಅಷ್ಟೇನೆ ಇದ್ರಲ್ಲಿ ಇರೋದು.
Petitioner being accused number 2 is seeking grant of bail. He was apprehended on 29/8/2024. Since then, he is in judicial custody. The investigation was undertaken and charge sheet came to be filed for the offense punishable under sections 323, 324, 307, 504, 506, read with section 34 of IPC. Have you produced the wound certificate of the injured?
ಹೌದೌದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ.
Where is it?
Lordship, can you take my lord
Page number?
typed copy, page 61.
Wound certificate discloses that he has, the injured has sustained cut, lacerated wound or left.
Page 2, my lord.
Lacerated wound or left glavital, GLB, TEAL region, measuring 10 by 4 centimeters. He has given the history book medical officer that he was assaulted by a known person with a knife. After investigation, charge sheet came to be filed against accused number 1 to 4. It specifically alleged that the petitioner had given a knife to the assailant for the purpose of assaulting the injured. The petitioner has abused the assailant, accused number 1, who then assaulted the injured. How many injured are there?
My lord, only one injured.
CW
My lord, in
one?
fact, my lord, the FIR and says there are 2 injured. But ಎಲ್ಲನೂ ಅವರು ತೋರ್ಸೋದು ಇಲ್ಲ. FIR ನಲ್ಲೂ ತೋರ್ಸೋದಿಲ್ಲ, ಇದರಲ್ಲೂ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲೂ ತೋರ್ಸೋದಿಲ್ಲ. According to the prosecution, he is the only injured.
There are 2 wound certificates, my lord. There are 2 wound certificates.
2 wound certificate ಇದೆ, but
2. ಮತ್ತೆ ಒಂದೇ ಅಂತೀರಿ. You produce the 2 wound certificate.
ಹೌದೌದು, sorry.
ಅಲ್ಲಿ wound certificate ಹೇಳಿದ್ರಲ್ಲ, ಒಂದು cut lacerated wound or left ಆಯ್ತು. The other injured sustained cut lacerated wound measuring 4 by 1 centimeter over the left elbow. Left elbow. The allegations made against the petitioner is of serious nature. The contention of the learned counsel for the petitioner that the petitioner is falsely implicated in the matter or that he has not committed any overt act cannot be accepted. Next para. Learned ICCP submits that the petitioner is a rowdy sheeter. Other than the present case, 4 other criminal cases are registered against him at Rajankunta police station. That is crime number 12 of 2016, 50 of 2016, 102 of 16, and 55 of 2019. However, learned counsel for the petitioner submits that in crime number 12 of 2016, name of the petitioner was dropped while filing the charge sheet. In crime number 50 of 2016, petitioner is already acquitted. But in crime number 102 of 2016 and 55 of 2016, charge sheet is filed against him and the trial is still pending. It is also contended by learned HCP that the petitioner is a rowdy sheeter and the rowdy sheet is not closed. This fact is also admitted by the learned counsel for the petitioner. However, he contends that in the present case, the injured have not sustained any grievous injury. And the petitioner undertakes not to commit any offense in future. Any offense in future. It is noticed that what about accused number 3 and 4?
My lord, accused number 3 and 4, my lord, accused number 1, my lord, your lordship was pleased to granted bail. 3 and 4 ಅವರು ಜೇಸಿನಲ್ಲೇ ಇರ್ಬೇಕು.
3 is in this. 1 is on bail.
1 is your lordship granted bail.
It is brought to the notice of the court.
ಏನ್ ಹೇಳು?
Accused number 1, who is the assailant,
4ನೇವರಿಗೂ ಕೂಡ ಆಂಟಿಸಿಪೇಟರಿ ಬೈಲ್ ಕೊಟ್ಟಿದೆ.
granted bail. And accused number 4, against whom serious allegations are made, was granted anticipatory bail. Considering all these facts and circumstances, I am of the opinion that petitioner may also be enlarged on bail subject to conditions which will take care of so and so. It is made clear that if the petitioner is found to have involved in any other criminal case since from the date of his release, the prosecution will be at liberty to approach this court seeking cancellation of the bail. Accordingly, I answer the above point in the affirmative and proceed to pass the following. Petition is allowed subject to conditions.
Machi.
If any criminal case is
ಇಲ್ಲ ಇಲ್ಲ
registered
ಹೇಳ್ಬಿಡ್ತೀನಿ.
after his release, prosecution is at liberty to come before this court seeking cancellation.
Aye.
I will not even hear you. I will just cancel the bail.
ನಾನೇ ಅವ್ರು ಬಂದ್ರೂ ನಾನು ಕೇಸ್ ತಗೊಳೋದಿಲ್ಲ, ಇಂಥವ್ರಿಗೆಲ್ಲ ಯಾಕೆ ತಗೋಬೇಕು?
Yes, next.
Outdoor matters, list 1, serial number 8, Keshavamurthy CN.
ಇದು enhance the sentence ಇದೆ. ಅದು ಏನ್ ಮಾಡ್ಬೇಕಂತ? ಹಾಗಲ್ಲ, ಬೇರೆ ಕೋರ್ಟಿಗೆ ಹೋಗ್ಬೋದಲ್ಲ. ಅಲ್ಲ, ಕನ್ವಿಕ್ಷನ್ ಆಗಿದೆಲ್ಲ. ಬೇರೆ ಪ್ರಾಪರ್ ಬೆಂಚಿಗೆ ಇರ್ಬೇಕು. ಮೇಂಟೈನಬಿಲಿಟಿ ಎಲ್ಲಿ ಬರುತ್ತೆ? ಆಯ್ತು ರೀ, ನಾವಲ್ಲ, ಬೇರೆ ಬೆಂಚಿಗೆ ಹೋಗ್ಬೇಕಲ್ಲ. ಬಟ್ ಮೇಂಟೈನಬಿಲಿಟಿ ರೈಸ್ ಯಾಕೆ ಮಾಡಿದ್ದಾರೆ? ಹಾಗೆ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಅವ್ರಿಗೆ ಕೇಳಿ ಯಾಕೆಂತ ಅಂದ್ರೆ ಅನೌನ್ಸ್ಮೆಂಟ್ ಕೇಳಿದ್ದಾರೆ ಸೆಂಟೆನ್ಸ್ CRPC ನಲ್ಲಿ ಅದು ಬರುತ್ತೆ, ಅನೌನ್ಸ್ಮೆಂಟ್ ಬರುತ್ತೆ. ಯಾಕೆ ಮೇಂಟೈನಬಿಲಿಟಿ ಕೇಳಿದ್ದಾರೆ ಅಂತ ಕೇಳಿ. ಎಸ್, ನೆಕ್ಸ್ಟ್.
Serial number 24, P. Prasanna Kumar.
For the petitioner, my lord, I've made the necessary correction with respect to the I've made the necessary correction, my lord, with respect to the representative of
The appellant is represented by special PP.
Please, my lord.
The counsel for the appellant submits that necessary corrections are carried out in the cause title. Now the appellant is represented by special PP. The submission is accepted. Office objection in that regard is ignored. List for orders, sir. List for orders. And
Serial number 27, Ashok Kumar Shetty.
counsel for the appellant is urgent, no representation, even when the matter is passed over twice and again called at 1:11 PM. Order sheet dated so and so reads as under. In spite of that, the office objections are not complied with, hence the appeal is dismissed. Then
Serial number 32, Fire sir.
needful done, counsel for the appellant submits that needful is done, office to verify. If needful is done, list for orders. Next.
Serial number 33, Manjula D.
Counsel for the appellant submits that the office objections are complied with. It is noticed that all the office objections are not yet complied with. Still the office objections. 1 to 3. The order sheet dated so and so reads as under. In spite of that, all the office objections are not complied with. Today, the matter is listed for the 5th time for complaints of office objections. I do not find any reason to adjourn. Dismissed. Next.
Serial number 35, Government Advocate.
My lord. Yes, my lord, kindly reissue bailable warrant, my lord. Say that they have not received it, my lord.
ಎಲ್ಲಿ ಹೋಗುತ್ತೆ ಹಾಗಾದ್ರೆ ಅದೆಲ್ಲ ವಾರೆಂಟ್ ಎಲ್ಲಿಗೆ ಹೋಗುತ್ತೆ ಇಲ್ಲಿ ಡಿಸ್ಪ್ಯಾಚ್ ಆಗಿದೆ ನಿಮಗೆ ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ಮಧ್ಯದಲ್ಲಿ ಎಲ್ಲಿ ಹೋಗುತ್ತೆ
They are saying that the SP office has not received the warrant.
ಇವರು ಹೇಗೆ ಯಾರ ಕೈಗೆ ಕೊಡ್ತಾರ್ರಿ ವಾರೆಂಟ್ ಹೇಗೆ ಏನು RPI ಕಳಿಸ್ತಾರ ರೆಸಿಪ್ಟ್ ಇದೆಯಲ್ಲ ಎಕ್ನಾಲಜ್ಮೆಂಟ್ ಇದೆಯಲ್ಲ ಅದು ಬೇಡ ಈಗ ಹೇಗೆ ಕಳಿಸಿದ್ರು ಅದಕ್ಕೆ ಏನಿದೆ ಅಂತ ತೋರಿಸ್ತೀನಿ ಎಕ್ನಾಲಜ್ಮೆಂಟ್ ಇದು ರೆಸಿಟ್ ಆದ್ರೂ ಅಟ್ಲೀಸ್ಟ್ ಇದೆಯಾ ಅದಲ್ಲ ಇಲ್ಲಿಂದ ಕಳಿಸಿದ್ದಕ್ಕೆ ಏನಾದ್ರು ಒಂದು ಬೇಕಲ್ಲ ಈಗ ನೀವು ಡಿಸ್ಪ್ಯಾಚ್ ಅಂತೀರಿ ಅವ್ರು ರಿಸೀವ್ ಆಗಿಲ್ಲ ಅಂತಾರೆ ನಾವು ಬದೈ ಅದನ್ನ ಕೇಳ್ತಾ ಹೋಗ್ಬೇಕಾ ಆರ್ಡಿನರಿ ಪೋಸ್ಟಾ ಆರ್ಡಿನರಿ ಪೋಸ್ಟ್ ಮತ್ತೆ ಹೇಗೆ ಅಟ್ಲೀಸ್ಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಆದ್ರೂ ರೆಸಿಟ್ ಆದ್ರೂ ಬೇಕಲ್ಲ ಕಳಿಸಿದ್ದಕ್ಕೆ ಅವ್ರು ಬಂದಿಲ್ಲಲ್ಲ ನೀವು ಕಳಿಸಿದ್ದಕ್ಕೆ ನಿಮ್ಮ ಹತ್ರನೇ ಇರುತ್ತೆ ಪೋಸ್ಟ್ ಆಫೀಸ್ನಲ್ಲಿ ಹಾ ನೀವು ಕಳಿಸಿದ್ದಕ್ಕೆ ರೆಸಿಟ್ ನಿಮ್ಮ ಹತ್ರನೇ ಇರುತ್ತೆ ಅವ್ರು ಕಳ್ಸೋದು ಬೇಡ HCP submits that the bailable warrant issued against the respondent is not received in the office of
SP Chitradurga, my
of
lord.
Police, so Chitradurga. The office do not have any document to show that the same was dispatched to the said office. Hence reissue bailable warrant against the respondent for rupees ಮೊದಲು ಎಷ್ಟಾಕಿತ್ತು 25,000. The jurisdictional police is directed to execute the warrant without any delay. Next.
Obliged, my lord.
Serial number 36, MR Irematar.
For appellant membership. Lordship, ಕಾಪಿ ಶುರು ಮಾಡಕ್ಕೆ ಒಂದು ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ IA.
Who filed IA1, IA2 of 19?
Appellant membership.
Till date you have not served the copy.
No, my lordship.
Heard learned counsel for the appellant. What is the prayer in that application?
My lordship, correction dates, correction, my lordship. Payment dates.
Correction in?
In appeal memo, my lordship. Permission.
Heard learned counsel for the appellant on IA2 of 2019. Even though the application was filed in 2019, seeking permission to make necessary corrections in the memorandum of appeal, the office objections raised on the same are not complied till date. Why? Even after lapse of 5 years. Hence, IA2 of 2019 is dismissed. List for orders. Next.
Serial number 37, Praveen CP.
Lord, in this case, they have not served it, my lord. As he has left the address, they'll file the report, my lord.
Summons,
Notice, my lord, notice order, right?
notice was issued. The notice issued to respondent returned answer as he left the address. to furnish fresh address. List down. Next, to take steps by furnishing fresh address. Next.
Serial number 39, Kempegowda CM.
Correct address.
Same, my lord.
Same.
Fresh address.
Fresh address.
Really non-receipt of report ಅಂತ.
They have not yet filed the report, my lord.
Hmm.
They will file the report.
When?
Shortly, they will file the report.
2019 ಇಂದ ಎಲ್ಲ ಹಾಗೆ ಬಿದ್ದಿದೆ ಅದು ಏನದು?
Kellu, they say that in 2022, they had filed the report, it seems, my lord.
ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ?
ಇದ್ರಲ್ಲಿ ಬಂದಿಲ್ಲ.
ನೋಡಿ ಅವ್ರ ಹತ್ರ ಕೇಳಿ ಏನಂತ. ಎಲ್ಲಿಯವರು ಇವರು?
Bangalore, my lord.
ಬೆಂಗಳೂರು. ನೋಡಿ ಕೇಳಿ ಪಾಸ್ ಓವರ್. ಹೇಳಿ ಅದೇನಂತ.
Serial number 40.
You verify the address of the appellant, respondent. Verify it. Learned counsel for the appellant undertakes to verify the correctness of the address of the respondent and to make his submission on the next date of hearing. List down. Verify and make your submission. Next.
Serial number 40, Sushil Tiwari. This is notice center, Mumbai.
Huh?
Mumbai. Report it notice.
You reissue notice to the respondent 1 to 4 if PF with correct address is furnished. Next.
List 2. Serial number 32, Vivek Saram, Siddharth B. Muchandi.
Lord,
Yes.
your lordships heard me yesterday.
Yes.
Lordships asked me to show my bona fides. Lord,
Yes.
compiled. But this shows that I've complied with every requirement.
You
under law.
served the copy on the other side.
Lord, it's not physically present.
Huh?
Party is here, my lord. He's not physically present.
Siddharth sir.
Respondent. Siddharth
Serial number
Muchandi.
32, Siddharth sir.
Lord, I'm appearing through VC play. I'm sorry, please. Lord.
Sir, he is filing a memo along with the additional documents.
Well, these are only the documents which were part of.
You are not here to serve the copy.
Please, my lord, I had furnished my set of documents and citations yesterday on the council. My lord, they can give a copy to me today. My lord, I will respond tomorrow.
How
Please.
it is to be served, sir? You are not before the court.
I understand, my lord. I'll collect it from the
There is
afternoon.
nobody to on your behalf.
Lord, I was. I'm sorry.
Like respondent number 2 is present, my lord. If I.
Hmm?
Respondent number 2 is physically present.
Respondent number 2?
Is physically present.
Who is the respondent?
Respondent number 2.
And on my behalf, let him collect the copy, please, my lord. I will make my submissions, my lord. Can it be taken up tomorrow?
Respondent number 2 is present before the court and he will receive it.
Please, my lord, let him receive it. My lord, may I make my submissions tomorrow? I'll have to verify these documents, what they are producing.
Then counsel for the appellant filed a memo along with additional documents.
But
If
these.
the then counsel for respondent number 2 appeared through VC. Respondent number 2 who was physically present before the court received the copy of the memo along with documents. Counsel for respondent number 2 takes the time to go through the documents and make its submission. List.
Lord, interim order to be extended.
Huh? Use the
Lord, the interim order is to be extended.
interim order extend ಇದ್ರೆ ನಿನ್ನೆ extend ಆಗಿದ್ರೆ. Yes, next.
Please.
Serial number 33.
Lord, the date.
Divya Purandar.
Yes.
Yes, Venkateshwaran.
Appearing for the appellant.
Yes.
For the respondent number 1,
Yes.
I have filed the application for vacating of the stay. They are enjoying the stay for the interim stay from the last 2 years.
Yesterday I heard the counsel for the petitioner.
This is a case, in case if the bank has followed all the statutory and mandatory provisions,
Amendments. Yes.
In this case, the petitioners filed that they have followed all the statutory and mandatory provisions of the law and other thing. If that is the case, what is the problem for them to face the trial?
Now, why unnecessarily the criminal?
No, no, the reason I will tell you.
Facing.
My lord.
is very serious question.
No, my lord,
Casual way
let
of
me
saying.
come to this. My lord, in this case, this is a student loan for studies abroad.
Admittedly, you stood as a guarantor.
Yeah, I stood as a guarantor.
Your sides.
Huh?
You offered your sides.
Offered the site, but it is not unsecured. It is unsecured. And subsequently, they have not followed any provisions under surface giving notice.
Please answer the question. You stood as a guarantor.
Yes.
Offered your sides bearing number 37 and 38. Executed mortgage deed.
Executed
Mortgage deed.
simple mortgage, not a full mortgage deed.
Okay, simple mortgage.
The documents have been impounded by the registrar under section 33 and 34, same documents which I have executed. I have filed already that letter from registrar and deputy commissioner of stamps and registration. They have impounded these documents because it is not mortgaged.
Yes.
And they have not paid the stamp duty. Now, my lord,
It was not mortgaged.
it was not mortgaged. It is not secured mortgage, what I am trying to submit. In this case, there were two sites, 37 and 38. But the bank has colluded with the purchaser. Only site number 38 has been auctioned. And 37 is not taken. See, I have pledged you both the sites, 37 and 38.
Pledging barala, the immovable.
Okay, I have mortgaged 37 and 38. But purposefully, he has sold only 38.
When sold when?
Is in 2009.
2009.
When the price of 38 itself was 30 lakhs, they sold at a throwaway price of some 11.9 lakhs. Without calling any bids, no notice to me. I am staying in abroad, studying there.
When it was brought to your notice?
Brought to the notice in 2015. And subsequently, when I came to know about this, I found that 37 is not auctioned, only 38 is auctioned. And there are no bidders, there is no proper procedure. Under Security Interest Act, they have to value the security under Section 8 of Security Enforcement Interest Rules of 2002, which they have not been done. They have to do proper valuation of the property before going for auction. Two valuers has to do this. They have not done that. That report they have to submit.
Sought for cancellation, setting aside the auction sale?
No, I've already filed for setting aside the auction sale. But subsequently, what has happened, 37, they have settled with me. For the site number 37, they went to civil court, which is again against the law. Under Section SURFACE Act, any excess recovery, if it is there, they cannot go to civil court. But they went to civil court, they got the degree, but subsequently I settled that.
Have you not contested the suit?
No, I have not contested the suit because I was not in India. I was outside, but I settled that 37. 37. Now, another, my lord, the both 37 and 38 original title deeds are with me.
The settlement?
Settlement is I paid whatever the dues they asked on 37 site. Now, whatever the dues they asked in excess of auction, I paid for that fully and got the settlement done. Now, another question is, the entire 38 and 37 original title deeds are with me. And now, this is been declared as an illegal construction also because that the same honorable court has issued a notice to BBMP to demolish this construction done in the site.
Whether you have challenged the auction sale in favor of accused number 2?
I challenged in the commercial court. That was dismissed because they said it is not Section 34 of SURFACE comes into the picture. That is why we are not doing it. But subsequently, in a similar case, the divisional bench of this court has passed an order when they have violated Section 8(5) of the SURFACE Enforcement Interest Rules, it has to be reconsidered. Accordingly, the judgment has been passed by the commercial court, which I have filed the case before the divisional bench, which is pending.
What is your grievance in this complaint?
In this grievance is they have entered into criminal conspiracy, both the bank and the purchaser.
Where is the complaint?
It is 28658 of 21.
You have filed the private complaint,
Yeah, I have tried the private complaint.
PCR number?
28568 of 21.
That is private PCR number.
CC number.
I'm asking PCR number, you are
No.
saying CC number,
PCR we are not filed.
charge sheet is filed.
No, not yet. Inquiry, they issued the notice and first, in the CC, they issued the summons. And before,
You filed the private complaint or police complaint?
the police complaint also I have filed. But that was,
Proceeding is out
Private
of
complaint, my lord.
Private.
PCR number 17957 of 2021. I have produced it at page 36.
17957 of
957 of 2021.
the learned magistrate took cognizance of the.
Yes, my lord, that is the order under challenge.
Where is that order? No investigation was undertaken.
No,
No.
my lord,
my lord, even before the summons were issued, they approached this honorable court for the stay. There is a criminal conspiracy which has been established by the document by the trial court. Trial court issued the summons to the petitioner as well as the purchaser and also sub-registrar who registered this property.
Which is the document you are referring to?
Which?
Which is the document?
Document I produced there was sale deed.
I produced
Which
it at annexure D, my lord, page 56. That is the sale deed.
Sale
executed by
deed
the bank.
56, wherein in this sale deed, they say that they have followed the SURFACE rules under SURFACE, they have filed this one, which is not so. I have to be served a notice. A statutory notice is a must. And I have filed the case laws. I am producing one divisional bench, similar matter, even after 30 years, they have not followed this rule of security enforcement interest rules. 25192 of 2019 GMDRT.
According to you, they have not followed the procedure and Surface Act.
Yes.
According
And
to
also they have
them-
not followed the mandatory provisions.
According to them, they have followed it.
Followed means they have to produce the documents to me. There is no notice.
That is to be produced before whom?
They have to give it to me. Even when they are selling the property, they have to tell me a notice that we are selling this property. They have to give an option to the borrower that so that the borrower can buy it or contest it.
That will not give rise to a criminal case, sir.
No, this is because they have undervalued the property.
Somebody instituted a suit that was dismissed by the commercial court. And now the appeal is pending before the division bench.
Yes.
Pursue that matter.
No.
How the criminal.
What the
case is-
divisional bench last time told is, you pursue this first criminal case. No, I mean, my lord, one submission is, what is wrong in facing the trial when they are pakka in all the document? They have forged the document. They have not followed the rules. Their own rules. They say under SURFACE. The trial court has heard. Your Honor, the trial court says, you approach the High Court. The commercial court has made it very clear. High Court has got the power, you go and approach. Accordingly, I approach the High Court. There is need for a trial to go on this.
How can trial go on SURFACE?
Because
rules, my
how,
lord?
how come the bank is more interested than the purchaser here?
Here before the commercial court.
Commercial court to set aside, I have produced the plaint, my lord. Plaint in the commercial court, my lord, is exactly the same. Set aside the sale deed. My lord, at page 84 is starting, my lord. My lord, exactly page 100.
Reason is not following the procedure.
Yes, my lord, whatever it is it a matter to be held before the magistrate? Day in and day out, we face proceedings before DRT. They should go and approach DRT or whatever. This is not a criminal law cannot be set in motion. He admits mortgage. He admits that SURFACE action is initiated. His only grievance is
Sir-
notice is not served. Is that what we have to agitate before the criminal court, my lord? My lord, may kindly see at page 100, he is asked for setting aside of the sale deed. That is the prayer before the
Why the
commercial court.
plaint was rejected by the trial court?
Under section 34, my lord, whether.
Not under
whether-
section 34, sorry.
The 34, let me ask. That's a question.
They
directed to
filed for
the-
rejection of the suit.
Under 7 rule 11, of course.
My lord, provision to reject the plaintiff 7 rule 11, but the bar, it is barred by law under section 34 of the Surface Act. Because whether this is a sale certificate issued by the authorized officer, why he is seeking the sale certificate essentially is because notice has not been served or it is not valued. All those contentions have to be raised under section 17 of the Surface Act before DRT. And any such matter which the DRT can consider is barred by law, barred by the civil code, including commercial code. Under section 34, it is rejected.
I'll come back at 2:30. I'll come back. Yes, I'll come back. Yes. Surface Act, section 34.
My lord, similar case is before the divisional bench. Can it be taken up on Friday or Monday?
No, sir. Already I heard her
No, no.
yesterday.
The similar case is there before the divisional bench.
Appeal against the
Yes,
dismissal.
appeal, commercial appeal. No, no, now it will
The
come up.
division bench will decide. This is a criminal case.
Yes,
It is entirely different.
No, that will also come up because that is also more important for me.
Let it come in. The division bench will decide it. Please. This cannot go before the division bench.
Sir, madam, ಯಾವ act ಹೇಳಿದ್ರು? Surface Act. ಇದು Surface Act. ಅದೇ. ಮೇಡಮ್ ಫಸ್ಟ್ ಇದು ಕರೀತಾರಾ? ಇದೇ ನಡೆಯುತ್ತೆ.
Like,
ಅಮ್ಮ ಮಾಡ್ತಾರಾ ಅದನ್ನ ರಿಸ್ಟೋರ್ ಮಾಡ್ತಾರಾ ಏನ್ ಟೈಪ್ ನಾವ್ ಏನೋ ಬಗೆಹರಿಸ್ತೀವಿ ಜುಲೈ ಆದ್ಮೇಲೆ 14th ಆಗಸ್ಟ್ ಬೇರೆ ಆಗಿದೆ SPV ಅಂತ ಆಗಸ್ಟ್ ಅಲ್ಲಿ ಅಲ್ಲ ಜುಲೈಯಲ್ಲಿ ಆಗಿರೋದು ನಮ್ದು ಇದೆ ಇದು 14 ಆಗಸ್ಟ್ ಆದ್ಮೇಲೆ ಇವಾಗ ಬರಲ್ಲಪ್ಪ ಅಷ್ಟು ಲಾಂಗ್ ಕೊಟ್ಟಿದ್ದಲ್ಲ ನಾವು ಇಲ್ಲಿ ನೋಡಿ ಅದಾದ್ಮೇಲೆ ಯಾವಾಗ ಬಂದಿದ್ದೀವಿ ಬರಲಿ ಸಿಸ್ಟಮ್ ಸೆಕ್ಷನ್ 29th ಜುಲೈಗೆ ಆಗಿತ್ತು ಅದು ಏನು ಬರೀ BW ಕೊಟ್ಟಿದ್ದು ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು MDW ಕೊಟ್ಟಿದ್ದು ಅವಾಗ ಫೈನಲ್ ಇಯರ್ ಇಲ್ಲ ಅಂತ ಹಾಕೊಂಡಿದ್ವಿ ಗೊತ್ತಿಲ್ಲ ನಾನು ರೇಗಿಸ್ತಾ ಇದ್ದೆ ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲದೆ ಇರೋದಿರುತ್ತಾ ಏನಾದ್ರೆ ನಮ್ದಾಗಿದೆ ಆಗಸ್ಟ್ ಅಲ್ಲಿ ಆಗಿದೆ ನಂದಾಗ ಫೈನಲ್ ಇಯರಿಂಗ್ ಹಾಕಿದ್ದೀನಿ 54 ಸರ್ ಅದರ್ ಸೈಡ್ ಬರ್ಬೇಕಲ್ಲ ನಿಮ್ದಾಗಿದೆ ಅಲ್ಲ ಅದರ್ ಸೈಡ್ ಬರಲಿ ಅಂತ ಪಾಸ್ವರ್ಡ್ ಮಾಡಿದ್ರು ಈಗ ನಿಂದ ನೆಕ್ಸ್ಟ್ ಒಂದು ನಡೀತಾ ಇದೆ ಅದಾದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ನನ್ನ ಪಾಸ್ವರ್ಡ್ಸ್ ನೋಡಿ ಬೇರೆ ಉಂಟು. ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ ಫುಲ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿಲ್ಲ ಯಾರು ಡಿಸ್ಪ್ಲೇ ತೋರಿಸ್ತೀನಿ ಈ ಫಾರ್ಮ್ ಕೊಡ್ಬೇಕು ಕೊಡಿ ಲ್ಯಾಪ್ಟಾಪ್ ಎರಡು ಕಡೆ ಇದೆ Serial number 33, Divya Purandar. That's Venkateshwaran.
Yes.
My lord, some small submission, my lords. Serial number 35, my lords, list 2. Morning, we filed the memo stating that the respondent has been read and the suit will be abated, my lords. But there are many other respondents. So inadvertently, we have filed the memo, my lords. We would want to withdraw it.
Already disposed of.
My lords, there are other respondents who are still alive. So, my lords,
No, it was disposed of on based on your memo.
yes, my lords,
Then
but there are other
After disposal of the appeal, how can you withdraw it?
We don't know, there is no such clarification which respondent is dead, my lords. So we kindly grant one short accommodation, next hearing date will
Do whatever you want. You have to give a reason why you have filed the memo first of all.
Previous hearing date, the appellant made the respondents made the submission that that the respondent in past passed away, my lords. So we have filed the memo with.
It was placed on record. Again, you have filed a memo
Yes, my
stating
lords.
that the appeal is abated.
Yes, my lords.
The same was recorded, appeal was dismissed. And how can you withdraw that?
We have intimated the other respondents also, my
Next,
lords.
next, whatever you want to do it. Next.
Appearing for the petition.
Yes. Yes.
This is Security Interest Enforcement Rules, 2002, page 65, Your Honor. Before sale of immovable of secured assets.
Sir, everything, even if
Allala.
your contention is.
In
to
this
accept
case,
it,
my lordship, in this case, I am a guarantor. I am not a borrower.
Please hear me forever. It is your contention that even though they have auctioned one of your sites, which was given as security, they have not followed the procedure as contemplated under law. Then
Yes.
how can you invoke the penal provisions for that?
Because
Section 32 of Securitization Act, Section 34 of the Securitization Act clearly bars such remedy.
34 is applicable only if it is a secured asset. I can quote,
But what about
I have
32?
quoted many Supreme Court judgments in my reply in the counter. It is not a secured asset. There is a difference between secured asset and unsecured asset. SURFACE comes only when it is a secured asset. As per SURFACE Act, Section 20 onwards, they have to register this with a central registry, which is not done. So it is not a secured asset.
Let us assume that Securitization Act is not applicable. At least civil court will have jurisdiction. What is your remedy? You have to seek this cancellation or setting aside the auction sale. How can you invoke the penal
Auction
provisions?
sale cannot be done in contravention to the principles of natural justice. A site which is 30 lakhs, you cannot sell away at 11 lakhs, sorry. So this is the manager in connivance with the purchaser. There is no auction purchasers. Where is they have not provided. And before they effect the sale, they have to give me an opportunity to the guarantor and the borrower, which is not shown. It is very clear. And also, under Section 9 of Banking Regulations Act, after 7 years, they have to seek permission from Reserve Bank of India. Any assets, if they want to sell, under Section 9 of Banking Regulations Act.
Yes.
This is more than 7 years. They have to seek permission. In this case, asset is not secured. And it has been impounded. I have produced the document in my written statements, wherein the documents which produced by the petitioner has been impounded. Once the documents are impounded under Section 33 and 34 of Karnataka Stamp Act, there is no relevance of mortgage itself. Even before approaching the court, I wrote a letter to the bank to clarify all these things. There was no reply from the bank side. In the two letters, 15 and even 2019, I have produced those documents. In this case, even if they say they are going under SURFACE, they have to follow the
What is the role played by this petitioner?
petitioner is a bank which has
Number one,
Chief Manager, Union Bank of India, Asset
the
Recovery
role
Branch.
played by him. What is your allegation against him?
he is connived with the respondent number 2 and auctioned the property below the market price.
The private complaint?
Yes, I have produced the documents before the trial court, the valuation of the property at that time.
Where is the private complaint? Have you produced the complaint?
My lord, I produced the complaint, my
Page
lord.
number.
Produced at 42, my lord. Page number 42 of my petition.
Even guidance value, they have not sold. They have sold less than the guidance value.
Where is the allegation made against accused number 1 in this complaint?
My lord, at page 44, my lord. There is no specific allegation against the complainant. What he says essentially at para 7 of the complaint, page number 44, that it is not registered under SURFACE. Thereafter, permission of DRT has not been sought. All those general allegations relating to the procedure which has been followed has been made, my lord. So according to the
There is a
provision of
criminal
equality.
conspiracy entered between the bank manager and the purchaser.
That
If
is
it is a mandatory and statutory provisions, if they want to follow, they
Where
have
is
to
the
follow.
allegation? Where is the allegation against the present petitioner in your complaint?
Yeah, the number one is the bank is the number one respondent accused one, number 1 in the complaint.
My lord, para
Number
4.
2 is the purchaser. Number 3 is the sub-registrar. Sub-registrar not even gone into the mother title deeds.
Not named the chief manager. No, my lord. It's only chief manager. My lord, may kindly see that's the whole. My lord, that's
This
the
is chief
rise of
manager
death of
means
petition.
because,
My lord,
Your
the
Honor,
CLD
my lord, if it is so, if the chief manager is a circular issued by this Honorable High Court of Karnataka, they have to obtain the board resolution and other thing. The circular was passed in May 22, 2022 by this Honorable Court. That bank, any representation, they have to mention the name. They are not doing so. In many of the cases, even while filing the wakalat, they have to mention their names, their authority, their power of attorney, everything has to be produced. So here, the name of the person is, this bank is located in a cantonment where this Valmiki Corporation is involved. Same bank, same branch, same people are involved in this case also.
No.
This is,
Let them be.
no, not that way.
Not be the ground
This is,
for-
I'm telling you how these bank people are involved. How can they sell without even valuation?
Sir, you said there is a conspiracy.
Yes.
Conspiracy by whom?
By
At
bank
what time?
bank manager,
Who is it?
the auction, Chandramouli, KS Chandramouli, that is in the sale deed.
He is not named Chandramouli at all. He is named chief manager. That's the main thing.
He was the chief manager. 1 second.
Whether he is an accused,
He is a chief manager. No, chief,
an accused.
no, chief manager, we have made it because he has changed from there to asset recovery branch.
Chief manager, that is designation could be an accused.
Correct, represented by, the problem is this chief manager has been transferred. There is a new chief manager with whom we have to file.
He is responsible. I cannot give you an answer. I am not here to give legal advice.
No, not that. That is the reason this Honorable High Court of Karnataka has mentioned, even when they're filing the petition, they have to mention the name of the chief manager and also authority, power of attorney have to be produced. This is a mandatory provision by this Honorable Court in circular.
I'm asking you in your private complaint. Who is arrayed as accused? Accused number 1 is chief manager.
Chief manager, yes. And the respondent number 2.
Respondent number 2, we are not concerned at present.
It is the number 1 and 2, they have entered into criminal conspiracy.
Chief manager means there must be some person.
As per the sale deed, it is the name of KS Chandramouli.
Mention of it in the private. But you have not stated anything about Chandramouli in your complaint. Have you stated anything?
No.
Then-
Name is not mentioned, but when
Why?
the summons have gone, they have appeared.
No, chief manager in 2021 has
Chief
appeared.
manager will
Yes.
appear.
No, this was in 2009 that
You know that Chandramouli executed the sale deed. He issued the sale certificate. What prevented you from mentioning that in the private complaint and making Chandramouli as an accused? Petitioner is not Chandramouli.
No, my lord, petitioner is the chief manager as on the date of the cognizance of the complaint was taken. Because we received summons.
It goes to the root of the matter.
Yes, my lord.
the root of the manager, whoever has occupied on that day position,
On
they
which
have,
date, sir?
no, my lordship,
The
here-
date of taking cognizance?
no, on the day, this sale itself, entire sale,
When the offense was committed?
According to him, 2009 when the sale deed was executed.
But admittedly, the petitioner was not the chief manager
Yes.
then.
Yes.
no, who is the chief manager also, we don't know. It is written here, who is the petitioner, name is not mentioned even in this.
Yes.
Now in this chief manager, who is the petitioner is not mentioned.
So, for control and counsel for the respondent number. Respondent number 1. Opposing the petition submitted by. Even though the respondent number 1 admits that stood as guarantor for the loan obtained by your daughter, is it?
Yes.
A daughter. And offered 2 sites as security. It was not a secured loan. Therefore, the provisions of securitization Surface Act will not come into force for invocation. And counsel submitted that none of the provisions
none of the procedure contemplated under law was followed by the chief manager of Union Bank of India before proceeding to hold the auction of site number 38. Accused number 2 cannot be cited as the highest bidder, as the said sale was for a paltry sum of money. No notice was issued to respondent number 1 before initiating the procedure for holding the auction sale. Under such circumstances, the entire auction sale is vitiated. The council submits that since the bank has not followed any of the procedure, the complainant has made specific allegations against the chief manager that he, in collusion with accused number 2 and 3, managed to execute this sale. For a nominal price, even though the site was valued crores of rupees. It is a clear case of cheating. Under such circumstances, the petitioner will have to face the trial before the trial court. They could produce the documents if they had followed the procedure for conducting the auction sale as required under law. But the petitioner is not entitled for any relief in the present petition seeking quashing of the criminal proceedings at the initial stage. Next paragraph. When counsel further submitted that the detailed averments are made in the private complaint, and on taking into consideration those averments in the private complaint, the learned magistrate took cognizance of offence, and if the same cannot be found fault with, the order in question is a reasoned order which do not call for any interference. Hence, he pays for dismissal of the petition. There will be and consideration and answer to the point in the affirmative for the following reason. Respondent number 2 filed the private complaint in PCR 17957 of 2021 before the trial court against accused number 1, accused number 1, that is Chief Manager, Union Bank of India, Asset Recovery Branch, Avenue Road, Bengaluru. Accused number 2 is the auction purchaser of site number 38, which was sold in public auction. And accused number 3 is the senior sub-registrar of registration and stamps, Batrayanpura, Kodigehalli, Bengaluru. Now, the chief manager of the Union Bank of India, who is holding the position as asset recovery, Union Bank of India, asset recovery branch, has appeared before this court seeking to quash the criminal proceedings, contending that since accused number 1 is the chief manager of the bank at the time of taking cognizance of offence, the petitioner is the chief manager who is in charge of asset recovery branch, it is he who is arraigned as accused number 1. In the complaint, in the private complaint, respondent number 1 hearing contended that the chief manager has colluded with accused number 2 and 3 and committed the offence. Nowhere in the private complaint it is stated that who was the chief manager who colluded with accused number 2 and 3 and proceeded to hold auction sale by not following any of the procedures as contemplated under law. During the course of argument, when counsel for respondent number 1 contended that it was one Mr. Chandramouli, who was the chief manager of Union Bank of India, who colluded with accused number 2 and 3 and managed to sell site number 38 belonging to respondent number 1 in favor of accused number 2 for a paltry sum and making a paltry sum. But strangely, no such averments are found in the private complaint, even though it runs into several pages. Next one. When the complainant has made allegation against the accused, against the petitioner, that against the chief manager, alleging commission of the offense under section 420, and 417, 418, 19, 423 okay. Admittedly, the petitioner was not the chief manager of the bank concerned when the sale of the site in question was held. Admittedly, the sale of the site was held in the year 2009. 2008. After the auction, the sale, sale deed was registered and the sale certificate was issued. Admittedly, respondent number 1 filed the suit, OS number
373 of 2020, Madam. 373 of 2020, my lord. I produced it at next year.
Before the commercial court at Bengaluru, seeking
Setting aside of the sale deed. At page 100, my lord.
withdrawal or cancellation of the registration of site number 38. To direct the defendants therein to pay rupees 50 lakhs to respondent number 1 hearing for compensation of rupees 25 lakhs and for costs and other consequences. It is not in dispute that the said plaint presented by respondent number 1 was rejected by the commercial court, which is under challenge before this court. But the fact remains that other than filing the said suit before the commercial court, respondent number 1 has not initiated any other action challenging sale of his site number 38 in the public auction. However, the appeal against rejection of the plaint is pending consideration before the division bench of this court. Next, in the meantime, the private complaint was deemed to be filed by respondent number 1, making the chief manager of Union Bank of India as accused number 1. In the entire complaint, the complainant has not made it clear as to who was the chief manager who colluded with other accused and committed the offense. Admittedly, the petitioner, who is the chief manager of the bank concerned at the time of taking cognizance, was not working as chief manager when the site in question was sold in public auction. Under such circumstances, under to array a accused, array a person as accused, there must be some specific allegations against him. And he should be named by the complainant to identify him and to relate the allegations made against him. But strangely, in the present case, the complainant has not made any such effort, but arrayed the chief manager of Union Bank of India without making it clear as to who is he and at what period of time he worked as chief manager and in what manner he colluded with the other accused or he has committed the offense. Under such circumstances, I am of the opinion that the present criminal proceedings against the present chief manager, who is the petitioner here, is liable to be quashed. Accordingly, I answered their point in the affirmative and proceed to pass the following. Petition is allowed. Petition is allowed.
Yes, ma'am. Lord, sale is in 2008, my lord, not 9.
Sale is 2008.
My lord. Please, my lord, pay for me.
In view of disposal of the criminal petition, the year number so and so stands disposed of. Yes.
Serial number 34, G. Ravishankar Shastri, T. H. Chandrasekhar.
Appellant.
Counsel for the appellant is present. Counsel for the respondent is absent, no representation. Order sheet dated 6/11/2024 reads as under. In spite of that, there is no representation. Hence, issue NBW against respondent through the jurisdictional police. In case of execution of the NBW, respondent shall be produced before the jurisdictional magistrate for passing the Lahapoli. The police is directed to execute the NBW with the assistance of the appellant forthwith. Please assist the police in executing the warrant.
My client is also, my lord, aged, my lord. I will instruct him.
On behalf of him, somebody must be there.
I will, my lord, convey to.
Then very good. Yes.
Please.
Treated as parted. In
Please.
the meantime, let the NBW be executed.
Please.
Yes.
Serial number 41, Venkatesh Somareddy.
May please.
Yes. Serial number 41.
Preparing for the
Ah.
Clarence Council. Please.
Yes, it was about to be disposed.
Please, I'm grateful for
Dismissed in the morning.
grateful for accommodating me. It was only because I was on my legs in another court. Could not complete my submissions there, my lord. I could not rush. I'm humbly grateful, my lords. My lord, there are two matters. One is first is 5419, my lords. Up to the 19th.
Why two petitions?
But two different crime numbers.
In 5338 of 2019.
That's crime number of Chikmagalur. Another is Mangalore. First is Mangalore.
First to 533 month.
533. That's the first in point of time, my lords.
Yes.
As far as 5338 up to the 19, there, though the petitioner's names are not there in the FIR, my lord, which registered stating that there were unregulated deposit schemes. In the course of investigation, names of the petitioners are added, stating that they have also participated, etc.
1.
They are accused numbers 3 to 13
Petitioners, huh?
petitioners.
3 to 13.
3 to 13.
Now, how many accused are there?
Hadimuru. One. Accused number complaint came to be registered against the accused number 1.
This 1 to 13 are in a charge sheet, is it?
My lord, charge sheet is not filed. ಆಗಿದೆಯಾ? Charge sheet? ಇಲ್ಲ. So stay it. So may I submit one aspect, my lords? With regard to the facts of this case, there are allegations against accused number one that she has collected funds from the public on some unregulated deposit scheme is allegation, my lords.
Allah, you are not named in the FIR.
Not named in the FIR.
Charge sheet is not yet filed.
Not yet filed.
Then why are before this?
Investigation was stayed by this honorable court, my lord. There was
Then
no
why the petitioners are before this court?
Before the court, my lords, because of their implication based on the statement of accused number one,
Are
they
you
said
arraigned as accused?
arraigned as accused.
Only
They are arrested, my lords, page 18,
page?
remand reports. Where they remanded and then they were granted bail, my lords. May I submit, my lords, one aspect, my fairly beg to submit. Since in the course of investigation, my lord, they were arrested. Kindly, my lord, reserve liberty to the petitioners approach this honorable court if need be on the filing of the final report.
ಅದು ಮೊದಲೇ ಆಗ್ಬೇಕಿತ್ತು, ಇವಾಗಲ್ಲ. 2019 4 years ಆಗಿದೆ ಇಲ್ಲಿ ಬಂದು
ಹೌದು.
ಸ್ಟೇ ಮಾಡ್ಕೊಂಡು.
That's true, my lords.
ನಾವು ಆರ್ಗ್ಯೂ ಆನ್ ಮೆರಿಟ್ಸ್.
I concede.
After 5 years ಮತ್ತೆ ನಾನು.
That's true. I concede.
New life, days of life, no.
But this investigation, I am informed, my lords, by this one investigation is almost ಆಗ್ಲೇ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ.
You got it stayed.
We got it stayed, but ಆಗ್ಲೇ almost ಆಗಿತ್ತು ಅಂತೇಳಿ. But one aspect I beg to fairly concede my handicap now, my lords. I understand the first question asked by the honorable court, my lords. So I understood that.
Consequences ಏನು ಅಂದ್ರೆ I can foresee.
ಹೌದಾ,
That
please.
was the advantage we are having since we worked in district court.
That's true, lords.
Otherwise, the implications, consequences, what is there in reserving liberty? Let them go.
For me, the foreseeing is, my lords, that I have the benefit of having practiced. So one sentence is sufficient, I understood. That's true, lords. That's true. Even if, my lords, if I have to argue on merits, I may have to concede to this honorable court that since investigation presently, my lords, is ongoing, I may not be able to.
Now, what is the allegation according to you?
Allegation against, my lords, one has collected funds. Number one, accused number one. And she was arrested and she confessed that all of us have also, everybody has joined hands together and they were also, other accused persons also invested and they also asked others to invest, etc. Though, my lord, strictly speaking, there might not be any offense, but, my lord, as far as unregulated deposit scheme is concerned, since allegations are made that they formed unregulated deposit scheme as per the remand report, my lords.
Yes.
This may be a case where they require matter for investigation, my lords.
Let them investigate.
Please, my lords.
What is the other, second one?
Second one, my lord, that's the first one. When they were arrested in this case, and they were granted bail, my lords, then some persons in, this is in Chikmagalur case, that case, my lord, I beg to submit, I have valid grounds to submit before my lord. Kindly see the second, that's criminal petition number 5419.
No.
Page number 8 is the FIR registered for IT Act 66C, 66D and 420. There, kindly see, my lord, we are arraigned as, the petitioners are arraigned as accused numbers 1 to 4. Page 11 is the complaint.
In all, how many accused in that case?
ಇದರೊಳಗೆ 4 ಜನ.
Only 4.
ಹೌದು. The complaint shows only a financial transaction ಇದರೊಳಗೆ, as far as page number 11.
Charge sheet is not yet filed.
Not filed. But the complaint as such, it shows only a financial transaction where some amount is invested and not paid.
There also you are apprehended?
There, my lord, yes, apprehended, released on bail. There, the contention is FIR registration itself is not correct because it's purely a financial transaction of saying that money is not returned, delegation.
The allegation.
Page 11, Sudesh. ಅವರಿಗೆ ಠಾಣಾಧಿಕಾರಿ ಸೈಬರ್ ಕ್ರೈಮ್ ಪೊಲೀಸ್ ಠಾಣೆ icoinweb.com ಎಂಬ ನಕಲಿ ವೆಬ್ಸೈಟ್ ಖಾತೆ ತೆರೆದು ಚೈನ್ ಲಿಂಕ್ ಸಿಸ್ಟಮ್ನಲ್ಲಿ ಹಣ ಹೂಡಿಕೆ ಮಾಡಿ ಹಿಂತಿರುಗಿಸದೆ ಮೋಸ ಮಾಡಿರೋ ಬಗ್ಗೆ ಮೇಲೆ ವರ್ಷ ವಾಸವಾಗಿದ್ದು ಪ್ರಸ್ತುತ ಸ್ವಂತ ಡ್ರಾಫ್ಟ್ ಶಿಪ್ಪಿಂಗ್ ವ್ಯವಹಾರ ಮಾಡಿಕೊಂಡಿದ್ದೇನೆ. ನನಗೆ ಲೋಹಿತ್, ಪುಷ್ಪರಾಜ್, ಅಶೋಕ್, ರಿತೇಶ್, ದೀಪಕ್, ಪ್ರಸನ್ನ, ಉದಯ್, ರಾಘವೇಂದ್ರ ಸ್ನೇಹಿತರಿದ್ದು ಇವರುಗಳ ರಿತೇಶ್ ಮತ್ತು ಅಶೋಕ್ ಎಂಬುವರು ನನ್ನಲ್ಲಿ ಮಧುಕರ್ ಕದ್ರಿ ಎಂಬವರು ಬಂದು iCoin Web, Madhukar Kabri is A1. iCoin Web ಎಂಬ ಚೈನ್ ಲಿಂಕ್ ಸಿಸ್ಟಮ್ ನ ವೆಬ್ಸೈಟ್ ನಡೆಸಿದ್ದು ಇದರಲ್ಲಿ. ಸೊ ಮಧುಕರ್ ಈಸ್ ಲರ್ನಿಂಗ್ iCoin, ಈ ವೆಬ್ಸೈಟ್ ಇಸ್ ಹಿಸ್ ಸರ್. ಮಧುಕರ್ ಕದ್ರಿ, ಸಂಜಯ್, ದೀಪಕ್ ಮತ್ತು ಲೋಹಿತ್ 1 2 3 4 ಈ ಚೈನ್ ಲಿಂಕ್ ಸಿಸ್ಟಮ್ ಅಲ್ಲಿ 70,000 ತೊಡಗಿಸಿದ್ದು 200 ದಿನ ನಂತರ 1 ಲಕ್ಷ ಲಾಭಾಂಶ ರೂಪದಲ್ಲಿ ಹಿಂದಿರಿಸುವ ಭರವಸೆ ನೀಡುವುದಾಗಿ ತಿಳಿಸಿದರು. ಅದರಂತೆ ಸ್ನೇಹಿತರಾದ ನಾವುಗಳೆಲ್ಲರೂ ಸೇರಿ ಸುಮಾರು 8 ತಿಂಗಳುಗಳ ಹಿಂದೆ ಅಕ್ಟೋಬರ್ ಕೊನೆಯ ವಾರದಲ್ಲಿ 15 ಲಕ್ಷ ರೂಪಾಯಿಗಳನ್ನು iCoin ವೆಬ್ ಎಂಬ ಕಂಪನಿಯ ಕಚೇರಿ ಇರುವ ಮಂಗಳೂರು ಕೇಸರಾವ್ ಗಣೇಶ್ ಮಹಲ್ ಕಾಂಪ್ಲೆಕ್ಸಿನ ಸೌಪರ್ಣಿಕ ಎಂಟರ್ಪ್ರೈಸ್ ಎಂಬಲ್ಲಿ ಮಧುಕರ್ ಕದ್ರಿ ಎಂಬುವರಿಗೆ ಹಣ ನೀಡಿ ತೊಡಗಿಸಿದ್ದು. ಇದಾದ ಬಳಿಕ ಮಧುಕರ್ ಕದ್ರಿ ನಡೆಸಿದ ಹಣಕ್ಕೆ ಲಾಭಾಂಶ ನೀಡದೆ ತೊಡಗಿಸಿದ ಹಣವನ್ನು ಹಿಂತಿರಿಸದೆ 1 ತಿಂಗಳಿಂದ ವೆಬ್ಸೈಟ್ ಅನ್ನು ಮುಚ್ಚಿದ್ದು. ಕಚೇರಿಗೆ ಬೀಗ ಹಾಕಿ ನಮಗೆ ಸಂಪರ್ಕ ಸಿಗದೆ ನಮ್ಮ ಒಟ್ಟು ರೂಪಾಯಿ 15 ಲಕ್ಷ ಮತ್ತು ಲಾಭಾಂಶ ಹಣ ಹಿಂತಿರಿಸದೆ ಮೋಸ ಮಾಡಿರುತ್ತಾರೆ. ಕರ್ತವ್ಯದಲ್ಲಿ ಮಧುಕರ್ ಕದ್ರಿ, ದೀಪಕ್ ಶೆಟ್ಟಿ, ಲೋಹಿತ್ ಎಂಬುವರು ಪಾಲುದಾರರಾಗಿದ್ದು ಇವರುಗಳಲ್ಲಿ ಮಧುಕರ್ ಕದ್ರಿ ಅವರ ದೂರವಾಣಿ ಸಂಖ್ಯೆ ಡ್ಯಾಶ್, ಸಂಜಯ್ ಅವರ ದೂರವಾಣಿ ಸಂಖ್ಯೆ ಡ್ಯಾಶ್ ಆಗಿರುತ್ತದೆ. ಇವರುಗಳ ವಿರುದ್ಧ ಕ್ರಮ ಕೈಗೊಳ್ಳಬೇಕಾಗಿ. This complaint is 6/7/2019. The complaint clearly speaks of the amount being invested and not repaid.
Yes.
When the complaint is registered on 6/7/2019, these persons, my lords, had been taken to custody in the other case. The reason is, in the second case, when they were taken to custody, there the second case FIR was registered on 21/6/2019. 21/6/2019, crime number 95 of 2019, Chikmagalur police station was registered. And I have produced a remand report. In this case also it is produced. Kindly see the document, my lords, the remand report. The next document, page number 12. That is the remand report in that Chikmagalur case, wherein these persons are arrested and produced, and the date of arrest, etc. You last may kindly see page number 17.
That is petitioners in second case, 533.
How they were arrested? You last page number 17, last name Madhukar Kadri. Arrested in
Arrested on
18/7/2019.
2019.
How
Then
18/7/2019 they were arrested. Now, my lord, when they were arrested in 18/7/2019 and they were detained. Now, in the meanwhile, my lords, this FIR comes to be registered.
no, before that it was registered.
Registered because, my lord, that FIR was registered earlier FIR.
Yes, 21/6/2000.
21/6/2019, when they come to know of that FIR, my lords, and the police were searching for us, and then this case is registered. 21/6 is that case. Even otherwise, my lords, the entire, my lord, the first
Number 90 of 19 was registered
on 21/6/2019.
6/7 number.
But this case registered on 6/7/2019. First case, my lords, why this is registered is actually, my lord, first case registered on 21/6/2019. Chikmagalur Town Police Station.
Yes.
And the police started searching for us in that case.
Second one,
Second one immediately after 15 days, 6th July.
that is what? Your
Please.
apprehension was much later.
Much later, but my lords, they were searching for us in that case. Now, my lord, my submission is, if the entire complaint is read, it shows we have given the money is not returned.
Not only that,
First ಹೇಳೋ ನಕಲಿ ಅಂತ ಹೇಳ್ತಾರೆ.
website.
ವೆಬ್ಸೈಟ್ ನಕಲಿ ವೆಬ್ಸೈಟ್ ಅಲ್ಲ, ವೆಬ್ಸೈಟ್ ಈಸ್ ಹಿಸ್ ಓನ್ಲಿ. ದ ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾಸೇಸ್ ಮಧುಕರ್ ಕದ್ರಿ ಅವರಿಗೆ ಕೊಟ್ಟೆವು ಪೇಮೆಂಟ್.
After that, the
My lord,
website
nakali
was
becomes, my lord, you must kindly appreciate, nakali is when Madhukar Kadri opens the account in the name of somebody else is nakali. That is not the case. The word nakali is used, my lord, say nakali website ಅಂತ ಹೇಳೋದು, but
with an intention to cheat ಅಂತ. ಈ circumstance.
no, my lord, this is purely a finance. In this case, it's purely a financial transaction. The amount is not repaid. Is the case, my lords.
Then
Now, my lord, alternatively, my submission is, in the first FIR which is registered, my lords, in Chikmagalur, the allegation is all of them have joined hands together, they have collected funds from the public in the first case. And now there cannot be a second FIR. This FIR, all these FIRs, my lord, wherever there is amounts are received from the public by any of them, either Veer Mangalore or Chikmagalur, my lords, or are required to be.
no, section 406 is not invoked in the second case.
Only for 20 is,
Provisions of IT Act is not invoked in the first case.
the sections I do concede.
Allegations are different. Even though the petitioners are the same, the accused are the same.
How?
Complainants are also different.
Complainants are different.
And
Complainants are different.
it is in different place, my lord. One is in Chikmagalur, another is in Mangalore.
It is not as if the same complaint has filed the two different complaints.
No, that's not the case. But the allegations, I leave it to my lords, so therefore my lords, both may be my lord dismissed, my lords, if after investigation, my lord, of course, that.
Will not reserve any liberty. I will
My
just
lord,
dismiss it. On
please.
merits, I will dismiss.
Please, even otherwise, my lords may take the liberty of submitting this, my lords. Now that I have understood, my lords, that both may be dismissed, my lords. Because anyhow, I can come even after filing charge sheet. That liberty I don't require, my lord. That's there. Even otherwise, I pray specifically.
But I will not reserve liberty. It will be dismissed on merits.
No, my lord, it's what's reserving is only, my lord, reassuring what is there in the statute.
For the senior advocate, you can find some way or the other. That is left to you. But now a carpet house in even burn in Tellan.
I myself submit, my lords. I only may submit like this, my lords.
Yes.
To I bow down to the honorable court's views, my lord, which I can understand, my lords. That since the matter is under investigation, at this stage, I am not pressing the petition. And petition may be dismissed.
No, anyhow, I have heard you at.
But please, I leave it to the honorable court, my lord, because any observations of this honorable court, my lord, should not affect me in any other future matter. Therefore, my lords, I don't want to proceed with the matter at this. I'm not pressing the petitions, my lords. Because the word reserve, my lords.
After addressing the learned senior advocate for the petitioner, after addressing the arguments on merits for some time, seeks permission to not press the petition. Hence, petitions dismissed.
Most good.
Both.
Please.
Past your matter, list one, serial number 8, Keshamurthy CN.
ಇದು ಒಂದು ತಿಳಿತಾ revision ಮಾಡಬೇಕು. Learned counsel for the appellant is absent, no representation. Last counsel absent, no representation, even when the matter is passed over twice and again called it. Since the office has raised an objection regarding maintainability of the appeal. It appears that the appellant is the complainant before the trial court. To file the complaint against the respondent alleging commission of offence punishable under section 138 of the accused was convicted by the trial court. But the complainant has preferred criminal appeal number 303 of 2020. Before the learner 75th annual additional civil and sessions judge at Bengaluru, CCH 76 N ನೀವು appellant ಗೆ ಇಲ್ಲ. Convicted and sentenced to pay fine. Okay, dispose of 2020. Before the Leonard so and so, seeking enhancement of sentence and to impose the fine, impose the maximum fine as provided under section 138 of an act. The third appeal was came to dismissed, which is and the said judgment is impugned in the present case. The first appellate court categorically recorded the finding that the appeal is not maintainable. But a revision should have been filed as the appellant hearing is not appellant hearing cannot be considered as a victim. To invoke section 372 of CRPC. But he is since he is a complainant seeking enhancement of sentence, he is required to prefer revision petition. I find considerable force in the reasoning assigned by the first appellate court while dismissing the appeal. In spite of that, the appellant is not present before the court, convinced the court regarding maintainability of the appeal. Hence, office objection regarding maintainability is accepted. Appeal is dismissed as not maintainable. Next. In spite of that, the counsel for the appellant is not present before the court, even though it is listed the basis of the memo moved by the appellant for listing.
Lordship, one submission regarding serial number 33, my lords. Kindly apologize for not having here at the time, my lords.
33 ಏನಾಯ್ತು?
33 complaints ಗೆ ಬಂದಿತ್ತು, my lords. ಅದರಲ್ಲಿ ಒಂದು objection ಇದೆ, my lords. ಏನಂದ್ರೆ R1, my lords.
ಆಯ್ತು, ಅದು dismiss ಆಯ್ತಲ್ಲ.
My lords, one second, my lords. R1 deceased, my lords. Expired ಆಗಿದ್ರು. But now deceased, hence case is abated against him ಅಂತ ಬರ್ದಿದ್ವಿ, my lords. So the objection raised was without seeking the permission from the court, how you have mentioned it, my lords. So if you permit, my lords, one day, my lords, we will file a new cause title, my lords. Kindly.
Okay, no, amend the cause title. Have you sought for permission?
No, my lords, earlier council made the mistake.
ಯಾರಾದ್ರೂ ಅವ್ರ
Please.
counsel ಅನ್ನ ನಾನು ಕರ್ಕೊಂಡ್
Please, my lords, they have, without permission, my lords, they have returned, my
How
lord.
you are permitted?
Yes, my lord. So I am requesting, my lords, we will change the cost title, my lords, of 1 day time,
ಅದು ಡಿಸ್ಮಿಸ್ ಆಗೋಗಿದೆ ಈಗ ಎಲ್ಲಿ ಪರ್ಮಿಷನ್ ಕೊಡೋದ್ರಿ?
please.